calendar in which individual cases have already been accused, and the defendant has received an initial appearance. Bonds have been set, and today we're going to get a snapshot or a status of the cases. If you are a defendant charged with one or more misdemeanor offense, please remember that you have a right to remain silent. Anything that you choose to say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. The matters that we're going to address is whether some of the cases are going to engage in a plea hearing, or whether the defendant is going to enter a not guilty plea and have the case arraigned and further notice for trial. Okay, let's begin with courtroom 2 or ACDC.
Good morning, Your Honor. This is Officer Milton.
Yes, good morning.
Before you is position 40 and 41, Mac Wheel.
Okay, thank you.
Got that.
40 and 41. Mac Wheel.
All right, courtroom 2, if you could please mute, please. I appreciate it. Thank you. All right, 40 and 41, Miss Mac Wheel is case numbers.
Mr. Wheel.
Mr. Wheel, excuse me. Mr. Wheel, your cases are 23 CR 1539J and 23 FTA 981. You were originally accused of battery and misdemeanor possession of marijuana from June 19, 2022, and subsequently there was a bench warrant issued. Please remember your right to remain silent, and your attorney is going to be Mr. McLean. All right, good morning, Mr. McLean. Ms. Falk?
Yes, Your Honor. The state's recommendation on this negotiated plea was count 1, 12 months probation, served 200 days. Credit for time served 104 days. That's from June 19th, 2022 to June 23rd, 2022, and then August 1st, 2023 until today. Balance probated, no further contact with Trinity McCullough. Stay away from 2444 Piedmont Road Northeast, 8 weeks anger management, 40 hours of community service. Count 2 is 12 months probation concurrent to count 1. State is asking the defense to stipulate to venue, factual basis, and identification.
We do so stipulate, Your Honor.
All right. And Mr. McLean, have you spoken to your client about these terms, and has he agreed to it?
Yes, Your Honor. By the way, the correct name and the correct spelling, it's not Mac, it's Mark, or it's Mark or Marquay. It's M-A-R-Q-U-E.
M-A-R-Q-U-E, okay.
Correct. And his last name is not Wheel, it is Wheeler.
Excuse me.
Bless you.
Bless you.
Thank you.
And Your Honor, I did neglect to sound for Miss Trinity McCullough.
All right. Is Miss McCullough available? All right. Mr. Wheeler, if you could please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings and your conversations with your attorney?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Are you entering into this plea willingly, knowingly, and voluntarily?
Yes, ma'am.
Is anyone forcing you or inducing you to take this offer today?
No, ma'am.
Mr. Wheeler, for purposes of the record, on our calendar and on our system, you are known as Mac Wheel. Do you have any objections to taking this plea under the this name, as well as the alternative name, Mark, M-A-R-Q-U-E, Wheeler?
No.
All right. So you have no objection to the errors in the spelling of your name?
Well, my name's actually not spelled the first way. It's actually spelled the correct spelling, which.
All right.
Oh, did I get it wrong? What is the spelling? What is the actual spelling?
It's M-A-R-Q-U-E, last name W-H-E-E-L-E-R.
Yeah, that's the one. That's the corrected name we have.
Right.
Yes.
So what I'm saying is that that's the name we're going to use as well. Do you have any objection to the original misspelling?
No.
All right. And Mr. Wheeler, if you decide to take this plea offer, you would have to give up your constitutional right to a trial in front of a judge or a jury to be able to go to court with your attorney to confront your accuser, challenge the witnesses and the evidence brought before you, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery and one count of misdemeanor possession of marijuana?
Guilty.
Your sentence for the battery charge is 12 months to serve 200 days, credit for time served 104 days. So your jail time is concluded. If you have no other holds at the jail, you will be at the probation office next week on Thursday before 3 p.m., where you will be placed on probation to complete an 8-week anger management program and complete 40 hours of voluntary community service. At all times, you're to have no contact with Trinity McCullough and to stay away from 2444 Piedmont Road in Northeast Atlanta. That concludes your sentence. Thank you.
Thank you.
Next, we have position 1, Ms. Banks.
All right, thank you. All right, is Ms. Banks still going to be in arraignment, Miss Adams?
Yes, Your Honor.
All right. Ms. Banks, my name is Judge Law. I just
Oh.
like to,
So I'm sorry to interrupt, Your Honor. No, she's not gonna be in arraignment. She is supposed to be, a not guilty, yes, a not arraignment, not guilty bond request. I apologize for interrupting you.
all right. So are you filing a waiver arraignment then?
No, Your Honor, you can go ahead and arraign her. I apologize for interrupting.
And do you waive a reading of the accusation?
Yes, Your Honor, I do.
Okay. Ms. Lakila Damaris Banks is case 22 CR 3972F. Ms. Banks is accused of willful obstruction of an officer from June 21st, 2022. Ms. Banks has also got a bench warrant, case 23 FTA 977, and appears to be from October 9th, 2023. Ms. Banks, you've been advised of your right to remain silent, and your attorney is Ms. Samantha Adams. You have been accused of one misdemeanor offense of obstruction of an officer. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the case against you beyond a reasonable doubt. If the prosecution prevails, you could be convicted and face a penalty of up to a year in prison and or up to a $1,000 fine. Given this information, how do you plead?
Not guilty.
All right. Both cases have been arraigned. And yes, Ms. Adams, what is the request for, is there a request? Yeah, there's a request for bond modification. Yes, ma'am.
Yes, Your Honor, there is. We're requesting a signature bond. I don't know if you can hear the judge, but we're requesting a signature bond for Ms. Banks. Her bond is $1,000. She served almost 36 days in jail thus far. In total, that's about 24, 25 days on the willful obstruction and about 11 days on the failure to appear. The reason why she didn't show up to court for that failure, the reason why she got the failure to appear, Your Honor, is because she was illegally evicted from her home and did not have access to a mail, so she was unaware that she actually had a court date. It wasn't because she was trying to abscond and miss court, because she does want to fight this case. So with regards to that, Judge, we are requesting the signature bond. Her signature bond is $1,000, and so we're asking, I'm sorry, it's a surety bond currently. We're asking for it to be changed over to a signature bond.
All right. Ms. Dunlap?
Thank you, Your Honor. So this case stems from, it looks like June 21st, 2022. The officers arrived at 3809 Boulder Park Drive to issue her an eviction. They made contact with her, let her know it was an eviction. She stated she never received any eviction letter. They told her she didn't have time to pack and that she needs to get her son dressed and grab her cell phone and medication. She stated that she wasn't going to leave. She sat on the bed, refused to leave. Officers tried to restrain her. She began resisting. They ended up putting her in a wrist lock, handcuffed her and escorted her out the house. She continued to resist. The officers had to push her in the control car. She did complain of pain to the wrist and stomach, stated that she was pregnant, but she also refused medical treatment. The state's recommendation was 12 months probation, serve 70 days, credit for time served 35 days, which was from the 21st of June, 2022 to, it looks like July 12th, 2022. And then from when she was arrested on the bench warrant of October 27th to today, but the balance is suspended. We are withdrawing the plea recommendation. We are saying that we need the bond to stay the same. She has a hold for fugitive from justice from Jefferson County, as well as, I guess, 3 other FTAs from 2013, 2015, and also another one from 2015.
Ms. Tyson, do you know what her Jefferson County hold is?
Let me check. It looks like she had an arrest from, let's see, 2019 for drug trafficking out of Alabama, and there is no disposition listed for that case. So that may be the underlying charge. And she also has another possession of heroin out of Alabama from 2019 that has no disposition for that case also. So that possibly could be the hold for Jefferson County, Alabama.
All right. It'll be $1,000 signature bond through the jail with a release to the Jefferson County, Alabama authorities only. She cannot be released on her own.
Thank you.
Next, we have on the probation revocation calendar, position 9 and 10.
Okay. And my probation officer is,
Good morning, Your Honor, Ms. Harris.
good morning, Ms. Harris. Ms. Harris, for purposes of the probation cases, may I place you under oath, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Appreciate it. Thank you. All right, this is a probation revocation matter. And did you say 9 and 10?
Yes, Your Honor.
Okay. I must have printed up the original calendar. Just give me a moment. I have up to 8 cases. Did we have additional? Is this Devon Mitchell?
No,
This is Kylie J. Rowe.
There was a reprinting of the probation calendar.
Okay, I've got, all right. For some reason, I've got her as positions 5 and 6. That's fine. Okay, this is Kylie Rajo, J. Rowe.
Yes, Your Honor.
Okay. And is Kylie Rajo at ACDC?
Yes, Your Honor.
Okay. Ms. Kylie Rajo, you have 2 open matters before us. The first one is the probation violation case, which is 23 PB 1467. And this was from October 9th, 2023, based upon the original conviction from 20 CR 001930F with regards to a cruelty matter. You've been advised of your right to remain silent, and your attorney is Miss Adams. All right. This is a probation revocation matter, and we're going to let our probation officer let us know why they're seeking to revoke your sentence. Ms. Harris?
Your Honor, Ms. Kylie was actually sentenced before you on April 18th of this year to 12 months to complete the BARC course within 60 days and to have no animals outside their lease. As of today, Ms. Kylie has never reported to our office. She has 4 months, 28 days remaining. Probation recommendation is to continue her on probation to complete the BARC course within 14 days. And of course, my apologies, also order her to do 50 hours of community service. Our recommendation is for her to start those community service hours within 30 days.
All right. And let's see now. Ms. Adams?
Yes, Your Honor. Thank you. Ms. J. Rowe is aware that she does have probation, and we would accept, she would accept being able to be reinstated. She has no problem with doing it. The issue is that she was not able to attend. Her boyfriend at the time took her out of town and then left her in another state. And so she was unable to return back to Georgia. She didn't have any form of communication. So she was pretty much, or money. And so she was pretty much stranded out there for a number of months. She recently got back to Georgia. And so she has been trying to get back on her feet. She's currently residing in a hotel where she can receive mail. So her goal is to not miss any more probation and also to fulfill her requirements as provided. I can also make sure that I send her updated address and 2 email addresses to probation so that they have a good contact information for her. Additionally, Your Honor, Ms. J-Ro didn't have any transportation. So it was going to be difficult for her to be able to get back and forth. She was originally staying in Gwinnett County. She is now currently much closer to Fulton County at the hotel she's residing in. And again, yes, she is willing to go ahead and take the classes and do the community service, Your Honor. So we do also request that her probation be reinstated.
It's got a Gwinnett County hold, so apparently they're going to come pick her up. I'm going to allow her to continue on probation. This is going to be marked as a probation violation on her record. She will be released to the Gwinnett County hold, and after she's released, within 48 hours, she must report to the probation office upon release from the Gwinnett County matter. And she must report at the first business day. They are open on Monday, Tuesdays, and Thursdays. Would that be correct, Ms. Harris?
Yes, Your Honor.
Okay. Immediately upon reporting to probation, she has 60 days from her first report date to enroll and complete the BARC program. She will have to complete the 50 hours of community service within those 60 days upon being, for the rest of the 4 months that she has left on probation. She has to start her community service work also within 60 days of reporting to probation. So every time she reports, she needs to indicate how many hours she has completed. If she doesn't start her community service or the BARC program within 60 days, probation is authorized to revoke the probation and require her to complete 60 days in jail to complete her sentence.
All right. You ready?
Courtroom 2, please. Yeah. Ms. Adams, any comment?
Nothing further, Your Honor. Thank you.
All right. Okay, this is a release to Gwinnett County and then to begin her probation upon being released from Gwinnett County. Thank you.
Next, Judge, we'll do position 10, Mr. Hayes.
Your
On
Honor,
the regular calendar?
I'm sorry?
Is this on the regular calendar or probation?
It should be on the regular calendar. Yes, Judge.
Okay.
Your Honor, while we're between cases for a moment, may I interject?
Go ahead.
Announcement on 27 through 33. Because of my request for a social worker visit, because of arrangements and logistics, I would like to ask to reset that either, let's see, today's Tuesday, either 2 days or 7 days.
Is it going to go on a competency calendar or a regular SAP calendar?
It might go to a competency calendar. It's looking like there are going to be some issues. We're not sure that it goes to that extent. And I'm going to have the social worker consult with me on what we think.
Okay, we'll reset it to this Thursday.
Okay, thank you.
And that would be November 9th. Because this was position 10 on the regular calendar.
Mr. Hayes.
All right. This is State versus Dustin Hayes, 23 CR 6685J. Mr. Hayes has been advised of his right to remain silent. His attorney is Ms. Adams, and he is accused of interference with custody and from a October 22nd, 2023 incident. Mr. Hayes, I understand, is going to enter a not guilty plea. Ms. Adams, are we going to arraign this case or will you file a waiver of arraignment?
Your Honor, we can arraign it. However, the state has provided a notice that they have sent this case up to Superior Court for review from the DA. I haven't gotten any updates from the state to find out whether or not it's been accepted.
Currently,
Uh-huh.
we have sent some, Your Honor, currently we have sent some information over to Deputy McCauley, who's over the crimes against women and, well, crimes against children unit, and have sent her some body cam video to review. So we're waiting for a final decision.
All right, so the CREC unit has not made a decision, Ms. Adams, so let's proceed. Again, will you be filing, will you be filing a waiver or shall I arraign the case?
Will you please arraign him, Your Honor? Thank you.
All right, and do you waive a reading of the accusation?
I do, Your Honor.
All right. As I've already indicated, Mr. Hayes is accused with this one misdemeanor offense. Upon his entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charge against Mr. Hayes beyond a reasonable doubt. If the state prevails, he could be convicted and face a custody of up to a year in jail and or up to $1,000 fine. Currently, this case is a misdemeanor pending the district attorney's review of the case to determine whether it should be transferred to her division as a felony matter. Given this information, Mr. Hayes, how do you currently plead?
Not guilty.
All right. I've got a request also for a bond. Mr. Hayes is charged with improper interference with custody with respect to an individual, BL. Ms. Adams?
Yes, Your Honor. Mr. Hayes he's been in Georgia for about 1.5 years. He has a GED. He actually has his own contractor service, and he's also worked at moving services. He was gainfully employed at the time of his arrest, and he has lots of experience in general labor. He has family in Alabama, but he also has many friends here, and he lives here. Your Honor, Mr. Hayes has also been incarcerated for 15 days here at Fulton County Jail. In addition to all of that, the facts that have been presented in the affidavit are not completely accurate, Your Honor, which is why Mr. Hayes maintains his not guilty plea. And so with that, Your Honor, we are actually requesting a signature bond. He does want to fight his case, and he has every intention on making sure he shows up to court to fight it.
I'm assuming he's got an Alabama address?
No, Your Honor, he actually has a Georgia address. It's in Lithonia.
All right, the current address we have on file is an Alabama address, so.
I can go ahead and update it in the chat.
All right, you might want to provide that information to our litigation manager, and I believe that's going to be Miss April Champion. Either she's hosting or Miss Champion, are you host? Oh, Melissa Grace, excuse me, Melissa Grace.
It's Miss Grace, Judge.
All right, appreciate it. Good morning, Miss Grace.
Good morning, Judge.
All right, so Miss Dunlap. Yes, ma'am.
Thank you, Your Honor. So this case stems from the 22nd of October. Minor 7-year-old BL was in the custody of the state of South Carolina. His mother, Regina Lucky, removed him from the custody of the state of South Carolina, and she was hiding the child in Georgia with the help of the defendant, who decided to rent a room for her and the child. When the mother was arrested on an outstanding warrant, the defender took child BL out of the parking lot where Regina Lucky was arrested. He hid in the stairwell with the child and changed the child's clothing to evade detection. He also took the child to a different hotel, and when he was arrested, he initially refused to tell the police where the child was until they released him. The child was recovered and is returned to South Carolina at this time. We are requesting that the bond stay the same. He went to great lengths to hide Miss Regina Lucky's child from authorities. As I just stated, the DA's office is already on record as still reviewing the case, so we're requesting that the bond stay the same.
All right. This is a 4 or 5 pages, an essay on the warrant. I just have some pertinent questions. Is this is the child born in wedlock? Or is this a out of wedlock? In other words, does legitimation an issue?
Your Honor, the child is not Mr. Hayes's child. So
that makes it even easier. Bond remains the same.
Your Honor, also too, just for the record, I know that the affidavit looks very long, but it's literally just repeated over like 3 or 4 times.
Okay,
Yeah.
but the fact, based on the narrative, if this is is there anything that Ms. Dunlap has said that is incorrect as stated in the warrant?
Yes, Your Honor.
What is incorrect?
So, Your Honor, with regards to the can you hear me, Judge?
Yes, loud and clear. Although your video is out. Oh, you gotten rather dark. There you go.
Okay, everything is went dark. Apologies.
Yeah.
But with regards
Oh, I think no, we're losing the jail reception.
at some point,
No, Miss Adams, I just lost your reception. Your screen froze. Okay, now it's a little better. Go ahead.
okay.
What
Yeah,
was incorrect about what Miss Dunlap just alleged?
Yes, Your Honor. What was incorrect was the fact that they were living with Mr. Hayes. He's not the father of the child, and he let the police know where the child was. He actually dropped the child off at the child's aunt, where the aunt was staying. And he informed the police of that. So he wasn't trying to keep the child. He, in fact, told the police where the child was. Yeah, and it was also cold outside. He put a jacket on the child. He wasn't trying to change the appearance of the child.
Yeah.
Just a
Your Honor,
minute.
if I could-
Just 1 second, please.
Hold on.
You're muted, Your Honor.
Bond modification is denied. If the state decides to decline making this a felony matter, the defense is free to revisit. Thank you. Same conditions apply. He's to have no contact with BL and with the biological mother. Thank you. Next case, please. Ms. Dunlap, can you hear me?
Yes, Your Honor, we can hear you. I just didn't know which case was next.
Courtroom 2 is
Your Honor, can we go to another area?
yeah, and I was going to ask courtroom 2 if you want to leave the Zoom and come back in. For some reason, either you've lost power in the room or the lighting in the room has gone down drastically.
We lost power in the building.
Oh, okay.
Yes, so you can go someplace else for now.
But I'll still need the attorneys from courtroom 2. So if they want to operate from their laptop, or how would that work?
Your Honor, I have my laptop and it seems to work. Let me just make sure.
Okay, I do see that you have your laptop also on Zoom. So if we lose the reception in courtroom 2, please go ahead and use your laptop, okay?
Yes, Your Honor.
All right. I'm going to start with Oconee County Jail.
Your Honor, he is actually my client. I have not been able to speak with him, so I would need a breakout room with him.
All right. We can put Oconee County Jail and courtroom 2 or Miss Adams' laptop. And let's put Miss Adams' laptop, PD Samantha Adams, in a breakout room. Let's see now. Let's hope 3 South. Who is that? Mr. McLean's client? 3 South. Is that Mr. McLean's client?
What's the name?
What's the name, Your Honor?
I don't know. I just see 3 South. I'm so sorry. I'm only referencing the location.
No, this is, I got 4 North right here in position 39.
Okay, and that would be Mr. McLean's client. Okay, thank you. This is the 4 North, referred to as Jail Court's iPhone. Mr. McLean, I believe that would be your client. Would it be correct?
Yes, 39, I believe, is Aliyahu West. That's
Okay.
a lady.
All right. Mr. Aliyahu West is case 23 CR 6673A. Mr. West, could you move a little closer to the phone? Perfect. Thank you very much. And your case number is 23 CR 6673A, in which you're accused of simple assault from October 24th, 2023. Mr. West, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. This is going to be a negotiated plea hearing. May I place you under oath, please? Raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. All right, Ms. Falk?
Yes, Your Honor. The state's recommendation in this case is 12 months probation, serve 30 days in jail, credit for time served 15 days. That is from October 24th, 2023. Balance probated 8 weeks of anger management, no further contact with Dedria Medlock, stay away from 590 Cascade Avenue, Southwest Atlanta, and 40 hours of community service. We would ask that the defense stipulate to both the venue, factual basis, and identification. We did, Your Honor, have an opportunity to speak with Ms. Medlock. She said she would be here on the Zoom this morning. I do want to let the court know that she does not agree with this plea offer, and she believes that the defendant needs more jail time.
All right. Any particular reason why more jail time is required? Was that voiced to the state?
I believe we should sound for Ms. Medlock so she can put her wishes on the record.
All right. Ms. Dedria Medlock? Dedria Medlock? I don't see anyone by that name.
Because I don't know this woman, never seen this woman.
I beg your pardon, sir? What do you want to tell me?
I apologize for disrupting the courtroom.
No, I'm just curious to know, what did you want to say?
I never even saw this woman in my life. I didn't even know why I'm even here.
Mr. West, if you have any questions about court proceedings, you and I can have a private breakout. It is not appropriate during this particular part of this particular proceeding for you to be speaking. Thank you.
All right. So, Ms. Falk, was Ms. Medlock given a Zoom link?
Yes, Your Honor, I believe so, but I can double check with Ms. Maldonado, who spoke with her yesterday.
Okay.
Yeah.
All right. While we are waiting on Ms. Medlock, Mr. McLean, my concern is that your client is taking a plea or with regards to an incident that he's not completely conceding to the factual basis. So,
Your Honor, although this is not a no-load plea that we're requesting, it is under the general principles of Alford versus North Carolina, or as I think it is more correctly known, North Carolina versus Alford. I've heard it both ways. He feels that it is in his best interest to go forward with this plea. That was his position yesterday. If his position has changed, then I will talk with him. But if he is sticking by that, he is fully aware and discussed with me the pros and cons. And I believe he wishes to go forward with this plea.
all right. Please unmute jail court iPhone. All right. Mr. West, I really need to hear from Ms. Medlock, first of all, because I'm not certain. This doesn't appear to be a family violence issue. Is there someone who's trying to chime in? Okay. Also, Mr. West, so I'm going to be asking you some questions just to make sure that you understand what you're pleading to. First of all, have you consumed any medication or alcohol?
No, ma'am.
All right. And are you satisfied with your attorney services?
Yes, ma'am.
Do you understand the charge that's brought against you?
Yes, ma'am.
Can you tell me what the charge is?
Simple assault.
Upon whom? I mean, you can read out any charge, but can you tell me what the charge is about?
The charge is saying that I either assaulted her, I either threatened her in a gesture or in a violent manner.
All right. And if I accept this plea, then you must be agreeing that that's what happened.
Or Your Honor, that he, in his best interest, should go forward with the plea.
Understood. But if you're taking this plea simply to get out of jail, then you will be waiving your constitutional right to ever challenge this charge in a court of law. Ms. Medlock would have to appear in a trial, and she will be subject to cross-examination and you have a constitutional right to never ever have to testify at all, because the state would have to prove that this incident did occur beyond a reasonable doubt. The state would have to carry its burden of proof. And if you are simply pleading guilty to this charge because you want to get out of jail, then you're willing to take a conviction on your record just because you want to get out of jail. Now, is that what you're trying to do? Or you are telling me in all sincerity that it's in your best interest to be convicted of simple assault against a woman that you claim you don't know?
I understand what I'm taking. I understand the plea that I'm pleading guilty to.
And Your Honor, if I may interject, we read the police report. There is no indication he actually knew Miss Medlock. She was a stranger to him. According to the police report, this happened at Kroger.
Understood. So, Mr. West, are you telling me then that you are agreeing that it's in your best interest to admit to these facts that you attacked a virtual stranger at a Kroger?
Yes, ma'am, I did. I did elbow her hand off me. That's true. The charges are true.
Okay. And is anyone forcing you or inducing you to plead guilty to this offense?
No, ma'am.
All right. And you understand, as I've explained, that if you decide to plead guilty to this offense, that you will be giving up your right to go back to court, to face the prosecution and the witnesses, as well as to confront your accuser, to have the assistance of counsel so that you can put your arm down, please. Put your arm down, please. You're going to waive your constitutional right and the opportunity to challenge the evidence and the witnesses brought against you, to be able to present any defenses or mitigating factors if you choose to do so, and to have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you telling me today that you are freely, willingly, and voluntarily waiving your constitutional right to challenge this charge in a court of law?
Yes, ma'am.
How do you plead to one count of simple assault?
Guilty.
Your sentence is 12. Well, is Miss Medlock present?
Your Honor, we did send Miss Medlock the Zoom link, and our victim witness advocate just attempted to reach out to her and received a voicemail. So Miss Medlock, for whatever reason, has chosen not to attend today.
All right. Mr. West, your sentence is 12 months to serve 30 days, credit for time served 15 days. So your jail time is concluded. You will report, if you have no other holds, you will report to probation next Thursday at 132 Mitchell Street. While you're on probation, you will complete 8 weeks of anger management. Your classes must begin within 30 days of your first report date to probation. That means by your second report date, you must have informed probation that you are enrolled in an anger management program. At all times while you're on probation, you are to have no contact with Deidre Medlock, and you are not to return to the Kroger store at 590 Cascade Avenue in Southwest Atlanta. While you're on probation, you will also attend and complete 40 hours of voluntary community service with any nonprofit agency. The community service must begin within 60 days of being released from jail. Do you have
Yes,
any
ma'am.
questions about a sentence?
No, ma'am, you just answered my question for me.
All right, thank you.
Okay, next we have position number 11 and 12.
Yes. I can run to my car and get my phone.
My apologies, Your Honor. The fire system just went out.
I can see both you and Mr. Adams in the courtroom too, and on laptop Samantha Adams. So either one still appears to work.
Yes, the courtroom too is gone, Judge, but
Our monitor is off.
it's
Oh, it's
completely,
frozen. Okay.
no, it's not frozen. It's off.
Black screen.
It's black.
Now it's gone. Now it's gone. Initially I saw it. Okay.
Yes, Your Honor, but
Well, you two both look rather cozy, but I think we can forge on. Is that all right?
yes, Your Honor, you were in the middle of giving your sentence, Judge, and when it
Oh.
went out.
I heard as far as the reporting time, the 30 days to get the classes started on the 8 anger management, the 40 hours of community service, and the stay away from 590 Cascade, which is Kroger.
And he has 60 days to begin his community service.
Understood. That was the point we didn't hear as it went black.
Yeah. But he
Thank you.
seemed satisfied. So I don't think there was anything off. Is that all right? We ready to move on?
Yes.
Yes, Your Honor.
Okay, thank you. I have Mr. Marquis Hood. Is that Mr. Hood? At the jail court iPhone?
No, this is position number 11 and 12, Mr. Mitchell.
Is this a?
Mr. Mitchell is on the probation
Oh,
revocation.
I'm sorry,
calendar.
probation. Okay, got it. Sorry about that. All right. Okay, this is Devon Lamont Mitchell. Is that be correct?
Yeah.
All right. Mr. Mitchell, my name is Judge Law, and we are addressing 2 of your cases. First one is the probation matter, which is 23 PV 1468, and that is your probation revocation case. And the underlying case in which the conviction was secured, that is 21 CR 1142J, in which the charges or the convictions were for DUI under the influence of alcohol, less safe, improper backing, reckless driving, hit and run. And Mr. Mitchell, with regards to these 2 matters, there is an intent to revoke your sentence based on an alleged violation of the terms of your probation. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Samantha Adams. Can you see and or hear Ms. Adams? Ms. Adams, if you please address your client.
Yes, Mr. Mitchell, can you see and hear me?
Yes.
All right, thank you. Ms. Harris, you've already been sworn. What is the reasons for the revocation?
Yes, Your Honor. Mr. Mitchell was sentenced on October the 17th of 2022 to 12 months to complete the risk reduction course, a drug and alcohol evaluation, a victim impact panel, and 40 hours of community service, and pay a fine of $838. Mr. Mitchell was reporting to our office and stopped reporting back in April of this year. He had a prior hearing back on June the 21st of this year with Judge Benson, and he failed to appear for that hearing. He has 3 months, 16 days remaining. Probation recommendation is to revoke his remaining balance.
3 months and how much?
16 days, Your Honor.
16 days. Okay. And do you know how many days he's already been in custody?
Yes, Your Honor, he's been in custody for 8 days.
8 days, okay. All right, so he stopped reporting April 2023, which was almost a year from the time he was convicted. He's got 3 months left, and he did not attend his last probation hearing. Okay, yes, Ms. Adams?
Yes, Your Honor. Mr. Mitchell has provided that when he did miss some appointments with the probation. He actually got COVID. He was out for 2 weeks, and then once he was cleared, literally after 1 day, he got COVID again and was out for 3 weeks, and that included the court date. He actually notified his probation officer. He was unaware that he was supposed to notify the court. Also, too, with regards to the conditions, such as some of the classes that he had to take. Judge, he lives in Gwinnett County. He does not drive. And so getting to and from probation was very difficult. He did mention to his probation officer that he wanted to try to transfer his probation over to Gwinnett County so that he can complete the things that he needed to complete. But he was advised that it was not possible for him to do that. Also, too, Your Honor, he did reach out to his probation officer regarding completing his community service and asked whether or not he can complete it in Gwinnett County. He was told no. And with regards to receiving the information for the victim impact panel and risk reduction classes, he was told that he did request the information so he can go ahead and get that, but he never received it. He was unaware that he was supposed to get his evaluation done. And then with regards, it was one other thing. Oh, the fees. Your Honor, with regards to the fines, Mr. Mitchell was paying the fine online. And then at some point he lost access to it. He informed his probation officer, but because he was being violated, he never regained access to it. So even if he was late, he was still not going to be able to pay because he didn't have the means to do so. Not necessarily because of the money, but because he was denied access to be able to do it. So with regards to that, Your Honor, we are requesting that his probation be reinstated. And also too, if he can work something out, see if he can work something out with probation so that it can be transferred out to Gwinnett County. I know that's outside the court's jurisdiction, but in order for him to be able to complete it as he would like to do so, because he's not trying to abscond, he's not trying to avoid, doing what he's supposed to do with regards to, the requirements of his probation judge. He just asks to make it so that it's more convenient for him to get to.
What did he complete between October and April? What items of his sentence has he completed?
Judge, he was actually making payments and visiting with probation. He did not complete any any community service, the victim impact panel or risk reduction, because when he requested that information so that he could get it done, it was never provided.
So he was convicted in October of 2022, and he has not completed risk reduction, alcohol and drug evaluation, victim impact panel, 40 hours community service. So it took him 6 months to try to figure out how to do it outside of Fulton County?
No, Your Honor. During that 6-month period is when he requested that information from probation, and it was never given to him. He asked multiple times.
But that doesn't mean, I'm so sorry. I'm just trying to understand the logic of it. So he wasn't given information about how to do it in Gwinnett County, so therefore he does not do it in Fulton County?
No, Your Honor.
Which is beside the point. But Officer Harris, is there a requirement by probation that Mr. Mitchell does his probation, his community service, his alcohol and drug evaluation, and his risk reduction in Fulton County, Georgia?
No, ma'am. I'm actually the PO over Mr. Mitchell's case. I gave him information back on November the 17th last year. I do tell them that they can do community service outside of Fulton County. We just don't have information for every single county and every single city. And they can look up their information by themselves. And if they find an organization, we just have to confirm that. But every month I've asked Mr. Mitchell, he just never gave me anything. And I did lose communication with him as of April of this year.
Okay. Anything else, Ms. Adams?
Yes, Your Honor. The other thing, I don't have Mr. Mitchell's grandmother on the line, but she has been present for a majority of their phone calls. And so she also would be able to bear witness to the requests that Mr. Mitchell has made to his probation officer.
If you know her name, I don't see, you can sound out for her, but I don't see, I see a Cindy's iPhone. Is that the grandmother?
No, Your Honor, she wasn't able to make it to the Zoom call.
Okay. I'm going to accept the state's recommendation. Mr. Mitchell's probation is revoked. He will complete the remainder of the 3 months and 16 days at the Fulton County Jail. And so with the 2-for-1, he will have up to 2 months to complete his jail time, after which his sentence will be concluded and his obligations are complete. Thank you.
Okay, next we have position number 23 and number 24.
Are we still at jail court iPhone? Okay.
Also, Judge, quick announcement, our computer went down, so we're just gonna have to share the laptop. So I'd like to go next after Gothi.
All right, Miss Francois, you have to thank Miss Adams for that.
Yes, thank you so much, Miss Adams. And then also, oh, she's muted. And then South Annex would like to go as well.
Okay, so do you have, okay, so I'm going to start with jail court iPhone. We have Brandon Logan, who is accused of criminal trespass in 23 CR 4225B. And then he's got a bench warrant in 23 FTA 987. Mr. Logan, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. McLean. And Mr. McLean, with regards to this one, this is going to be a arraignment and a modification of bond. Would that be correct? I'm sorry, could we unmute the laptop for PD Samantha Adams?
There we go. Correct, Your Honor.
Okay, and will you be filing a waiver of arraignment?
Your Honor, we'd like the court to simply remind him of the maximum punishment and the fact that he will be contacted as to court dates. We would like to waive the formal reading of the accusation, have him arraigned.
All right. Mr. Brandon Logan, as I've indicated, you are formally accused of criminal trespass from February 7, 2023. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the present time, we do not have a trial date, but the Fulton County Clerk's Office will be in contact with you and the Public Defender's Office as to when the case will be placed on a trial docket. I honestly have no clue when it's going to be set for trial before the division judge, so I cannot give you that information. But I can tell you that at the time of the trial, you will be represented by counsel, and it will be the prosecutor's complete burden to prove the charge against you beyond a reasonable doubt. If the prosecution does prevail, you will be convicted of this offense, and the sentence would be up to a year in prison and or up to $1,000 fine. Given this information, how do you currently plead?
Not guilty.
All right. This case has been arraigned. Mr. Logan is presently in custody pursuant to a bench warrant. And Mr. McLean, what would you like me to know?
Yes, Your Honor, as far as we can tell, looking at the booking sheet, the $1,000 surety bond on the FTA itself is what is holding him. The other case is apparently still on the bond, and that's correct. The only thing that would do him any good at this point is what we're asking for, which is to convert that to a signature bond, if possible, Your Honor. We'd like Your Honor to consider that simply because of the nature of the charge being a trespass. When I read the police report, the basic point was that a bunch of people were in an abandoned building that is owned by the county because it once upon a time was a multi-story hotel, and he was not the only person there. And a lot of people were staying there, and sometimes you need a place to sleep and lay your head. Yes, lay your head. So not trying to make excuses for him, Your Honor, although it sounds like I am. He would really appreciate a signature bond, and he will. I've told him the methods by which, even if he doesn't have a good mailing address, he will check at the clerk's office at the public computer on the counter to make sure he never misses a court date again.
All right. Miss Falk, yes, ma'am.
Yes, Your Honor. This is actually the second time this defendant has failed to appear on this case. Mr. Logan did fail to appear in the magistrate court in Fulton County, March 28th, 2023. The order signed by Nancy Mao states that the officer appeared, defendant failed to appear. And at that point, the court found sufficient probable cause to bind the case over to the state court of Fulton County. At that point, we took over the case, took out took out the charges as an accusation, and the defendant failed to appear again on September 20th of 2023 before Judge Porter. We're looking at his history, and we actually see that he is a multi-state offender with 20 cycles out of excuse me, I actually misstated, 25 cycles out of Illinois. One of them was the fact that his most recent was from November 15th of 2020. He has arrests for assault, battery, criminal damage to property, battery again. So he does have a lengthy history out of Illinois. We do have concerns that Mr. Logan, if released on a signature bond, will for a third time fail to appear on this case. And the state hasn't heard a reasonable explanation why he failed to appear the other 2 times on this case. For that reason, we are asking that the bond remain the same. I will put on the record that the state's recommendation was 12 months probation, serve 18 days in jail, credit for time served 9 days, balance suspended, and stay away from the address at 4330 Fulton Industrial Boulevard, where he was found with the other 2 individuals. The state is removing that recommendation from the I guess, purview of the defense. So we are asking that recommendation be withdrawn. That's all for the state, Your Honor.
Your Honor, and to the state, we wouldn't mind if you held the offer open a couple more minutes after the court rules.
It's going to be a $50 cash bond. Stay away from the location.
Very good.
Your Honor.
Logan, would you like to consider a plea offer of time served and balance suspended and close the case?
My attorney.
It's up to you. I can go into a breakout session and discuss it with you confidentially, which is our preferred method. But you and I discussed the offer yesterday fully, and I think you know what the offer is. So would you like to talk to me in private? We can do that.
Order. Yeah, can we take a second to speak with?
All right.
Yes.
It'll be short in a moment. Jail court iPhone, do you have another case?
Judge, who would like to go here and
Okay, if I can take one of the cases with Miss Adams, then Mr. McLean can jail court iPhone. Do you have a separate laptop, Mr. McLean?
No, Your Honor, but because they are an iPhone, because it is a telephone, if they don't mind just calling 404-612-2392, that'll be the phone a few feet to my right.
Okay.
And I'll talk to him on the phone.
All right, Mr. Logan, if you can step back, please. I'll need to talk to the deputy right there. Thank you. Deputy?
Yes.
At jail court iPhone, Mr. Logan needs to talk to his attorney. Would it be possible for you to call the courtroom 2 at 22392? 22392?
22392?
Yeah, 404-612-2392. And then come, and do you have another case there?
Okay.
And do you have another case?
Not on this floor. I would have to go down the hall to a 4 South.
Okay,
But
so
we're all
Mr. Logan, was your last case presently?
Yes.
Okay, please call courtroom 2 so that Mr. Logan can talk to his attorney.
Okay.
Thank you very much.
And I think they do realize because it is a cell phone and not a county phone, they will have to dial the whole number. 404-612-2392.
Okay. Miss Francois, who is next, please?
this is gonna be positions 20 and 21, Kilpatrick.
Your Honor, I have not had an opportunity to speak to Mr. Kilpatrick.
Okay, we can just move on to the next one.
So we can just move on to the next one and come back to him so I can have an opportunity to speak. to
I
him.
have South Annex. I have Sergeant Smith there. Good morning.
Good morning. I have Jonathan Vaughn and Jarvis Montgomery.
All right, Francois, is it okay to move there or did you have a different order?
Yeah, you can do South Annex and then come back
Are
over
they-
here to courtroom 2.
Are they with you, please, cases?
I got your cases too. I got.
Okay, no, I mean the two on South Annex.
Oh, I'm not sure. Let me see.
Your Honor, I think that they, what position numbers are they, Your Honor? Because they may be Mr. McLean's cases.
They actually are. Mr. Vaughn is Mr. McLean's case.
Yeah, I'm asking for a reset.
Okay.
Your Honor, with regards to Mr. Vaughn, Mr. McLean, he's waiting for the phone, but he has an announcement.
Okay.
Your Honor, after consideration of reading all the documents, we're asking for a reset for a week or two. It's not going to harm freedom unless something radically changes, because he also has a no bond other matter.
We're gonna
And-
reset it to November 21st.
Not hot, it ain't gonna hot.
No, they not.
And if there's a change, Your Honor, and if it becomes a matter of freedom, we will certainly ask the court to put it back on a quicker calendar, if at all possible.
That'll be fine.
Thank you.
You can do it on a Tuesday or a Thursday, either one.
Very good.
All right.
That works. That
And
works
then just hold for a minute. Sergeant Smith, Mr. Vaughn's case is reset November 21st. Who were your other two?
The other one I have is Jarvis Montgomery.
Is that also Mr. McLean's?
No, Your Honor, that's a conflict case with Miss McLeod.
Miss Maureen McLeod, are you on Zoom? All right, Mr. Montgomery's case, we have to hold until his attorney is available. And who was the third case, Sergeant?
I only had two. Mr. Vaughn, though, he's supposed to have a probation revocation order sent on the 2nd. We never received it.
All right, Officer Harris? Officer Harris with probation?
Yes, Your Honor.
I'm Sergeant Smith at South Annex has Jonathan Vaughn. Do you have an outstanding probation order that has yet to be filed?
I don't think so, Your Honor. Let me check.
Okay.
I think any probation any probation filing that he has, I believe, is not a misdemeanor.
Oh, okay. In that case, don't worry about it. Sergeant Smith, y'all would need to check with felony probation.
Okay.
Thank you. All right, so Mr. Vaughn is reset and Mr. Montgomery is Miss Maureen McLeod. I still don't have Maureen McLeod, so that brings us back to Deputy Francois.
Yes, Judge, I would like to do on the probation calendar, positions 1 and 2, Alexander.
I'm coming. I gotta watch it.
We get,
All right, South Annex, please mute. Thank you. All right.
Mr. Alexander?
All right, this is Ryan Alexander. All right, let's Mr. McLean, would we be able to just tilt the laptop a bit towards Mr. Alexander? Perfect, thank you. This is 23 CR 7584H, in which Ryan Alexander had a conviction. The charges were criminal trespass, willful obstruction, theft by taking, and possession and use of drug-related objects. He has a probation warrant under 23 PV 1469. Mr. Alexander, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Ms. Harris, you have been sworn. What are the reasons for the revocation of his sentence?
Yes, Your Honor. Mr. Alexander was sentenced on what date was this? Oh, November 17th of last year to 12 months to complete a shoplifting course and pay monthly fees of $49. As of today, Mr. Alexander has not reported or completed the course. He has 50 to 8 days remaining on his case. Probation recommendation is to give him credit for the time he served and to close his case.
Mr. McLean, any objection?
No objection, Your Honor. Thank you. I've consulted with him and he has no objection.
All right. Mr. Alexander, with regards to the time that you've served at the Fulton County Jail, that will be commuted to your time served for the probation violation. Your case will be marked as a probation violation, and that concludes your obligation of this sentence.
If you have nothing else holding you, you will be released today. If there's nothing else holding you, you will be gone. Go home, stay out of trouble.
I'm sorry?
I was just telling him if he has nothing else holding him, he will be released tonight or, within 24, 48
Yeah.
hours, as soon as they can.
That would be correct. If he has no other holds at the Fulton County Jail, he'll be processed and released within 24 hours.
And the other part was just, go home, stay out of trouble, and good to meet you.
All right, Mr. McLean, ditto.
Thank you.
Okay.
You understand what?
That's it.
All right, so.
Next case?
Position 25, Ramsey.
That's also McLeod.
That's McLeod's case?
Adams.
Yes.
Talk to him while we doing some more.
Who am I talking to? So Judge, position 25 is Ms. McLeod's case, so we're gonna have to hold off on that. If Ms. McLeod is not signed on.
No, she's not. I have someone at the Oconee County Jail. Am I waiting for?
Yes, Your Honor, that is Mr. Garlington. He is on the probation calendar. We're ready whenever the court is.
Okay, Oconee County Jail, while Deputy Franshaw gets my next case, could you unmute, please? Yes, and did you, what did you say the name is, please?
Your Honor,
Garlington?
yes, Marvin Garlington. He is
All right.
number
3 and 4 on the probation calendar.
Yes, Your Honor.
All right, Mr. Marvin Garlington, my name is Judge Lal. I am speaking from Fulton County, Georgia, and you have a probation revocation matter with the Fulton County State Court. The original case is 22 CR 6701A, in which the conviction was for battery, family violence, and your probation warrant case number is 23 PV 1466 from May 24th, 2023. Mr. Garlington, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Miss Samantha Adams. Our probation officer is Miss Harris. And Miss Harris, what is the reason that we're seeking a revocation in this matter?
Yes, Your Honor. Mr. Garlington was sentenced to probation on October the 20th of 2022 to 12 months to complete the 24-week domestic violence class. As of today, Mr. Garlington has not reported nor provided proof that he started the class. He has 3 months remaining on his case. Probation recommendation is to give him credit for the time he served. I think to our records in the jail, he's been in there since July of this year. So that is the reason for us to request to time serve his case.
Ms. Adams, any objection?
No objections, Your Honor.
All right. Mr. Garlington, based on the probation officer's recommendation, I'll accept that. This will be marked as a probation violation on this particular case. The time that you've already served will be commuted to this particular sentence, and that concludes your obligations for this case. Thank you.
Position number 5 through 8, Benjamin Flowers on medical.
Your Honor, I do
May I be excused?
Yes, Officer Harris, is that it? Was that all our probation cases?
Yes, Mr. I think it was originally positioned, Mr. What was his name? I'm sorry. Mr. Edwards, he's was taken off the calendar. He was scheduled to see Judge Taylor on next week.
Okay, understood. Thank you so much.
You're welcome. Have a great
Free to
day,
go.
Your Honor.
And Your Honor, with regards to Mr. Flowers, I do need to speak with him momentarily. I have met with him. I just need to update him on some information that I got last night and follow up with him about how he would like to proceed.
We would need to do a breakout because I don't have a phone where I am.
Okay.
All right.
And I want to make an announcement. I'm sorry. I had other guys out on 3 South. The lights went out, so I had no power, and I brought him around here to medical. So just so happened the computer over here working.
All right. Miss Champion, if you could put Samantha Adams and medical in a breakout room, and we'll be in a brief recess. Miss Grace, would you please contact Maureen McLeod and see if are we holding for her? Maybe she might.
I contacted Miss McLeod. She's going to sign on in the next 10 minutes, Your Honor.
All right, appreciate it. Thank you. And yeah, let's put Miss Samantha Adams and medical in a breakout, please. Thank you.
And good morning, Judge Rose Woodward, Public Defender's Office. I just have a brief bond motion for position 42, Richard Wilborn, whenever the court is ready.
We have a bit of a infrastructure. Power went out at the jail. So everyone is relying upon other devices. See, Richard Wilburn, okay.
Yes, Your Honor. Just wanted to make myself known, but
I don't know whether he is at the courtroom 2 or another location. So as soon as he appears, then we'll be able to address that. So it's just a question of waiting to see who appears. But presently, we'll just be in a brief recess while Miss Adams is in a breakout. Okay?
thank you, Judge.
All right, thank you.
Good
I have,
morning.
David Schnipper, are you counsel, sir?
Yes, ma'am. I'm number 14 on the calendar, Dewan Joseph Jewell. And he should be on. He also has cases number 15 and 16, but I do not represent Mr. Jewell in those matters. I do represent him on number 14, ma'am.
You represent him on position 14 for the incident from November 2020, but you don't represent him on the incident from Halloween this year?
Yes, ma'am. And then there's a number 16 is related to a warrant, respectively, that you signed in November of 22. I was told that had to do, I think, with pretrial services or something. I do not represent him on that either.
Okay.
But I do represent him on number 14.
All right. Mr. Dejuan Jewell is actually on a separate Zoom panel. Is he, I'm assuming he's not in custody at the present time?
No, he's out on bond.
That is correct, Your Honor. He was released on the FTA on November 2nd after paying a bond in the amount of $11,000. That bond was paid out through Jet Bonding Company.
Okay. So in that case, Mr. Schnipper, Mr. Jewell's case is going to be further notice for trial. Mr. Schnipper, you as you on Zoom and Mr. Jewell's on Zoom. Mr. Jewell, attorney David Schnipper only represents you on the November 7th, 2020 case involving the 1 count of battery, family violence, and the 2 counts of cruelty to children in the 3rd degree. With regards to your battery charge from October 31st and the bench warrant, Mr. Schnipper does not represent you. So if you want to go and talk to Mr. Schnipper about representation, that's entirely up to you. But you are presently out on bond. And please remember that the conditions of the original bond all remain in place. And which is no further contact with Candias Howard and to stay away from the courthouse unless you're there for official business. Any questions, Mr. Jewell?
No.
Okay, you're free to go. And just make sure your address is current with us at all times because we will send you notice for your next court date.
Thank you, Your Honor. May I please be excused?
Yes, Mr. Snippet, just 1 second. Okay, yeah, he's got a plea hearing in your case with him on November 9th in courtroom 2E with Judge Mather.
Yes, I am aware of that. Yes,
Okay.
ma'am.
All right,
Thank
Mr. Jewell, don't forget to show up for that. All
Yes,
right,
ma'am.
thank you, folks.
Thank you. Bye-bye.
Bye-bye. All right, Miss Adams, you've conferred with your client. Anything to report?
Yes, Your Honor. We would like to plead not guilty and have a bond request.
And I do apologize. Can you remind me the position number in that case again?
Yes, Your Honor. Just one moment.
Position number 5 through 8.
Okay. Yeah. There we go. 5 through 8. Okay. Okay. Are you filing a waiver of arraignment or shall I arraign the cases?
Can you please be arraigned, Your Honor?
Oh, looks like courtroom 2 is up and running.
Your Honor. Can you hear me?
Someone's device is on, it has to be. Your laptop is muted, so let's do another audio check. 1, 2, 3. There's some kind of feedback from the courtroom. Is there a microphone right there too?
Yeah. Is that better?
No.
All right, Miss Adams, can you hear me?
Yes, Your Honor.
It's getting some feedback
Yeah.
from.
You said yours is muted? This is strange.
Is there a phone or anything that is on in courtroom 2 that's connected? All right, if you'd like, and Miss Adams, do you waive a reading of the accusation?
Yes, Your Honor.
Okay, please mute courtroom 2. Mr. Flowers, medical, could you please unmute?
This is my.
Mr. Flowers, again, we're going to revisit your 4 cases in which 2 of them are bench warrants. The 2 original cases are 23 CR 2592D, in which you were accused of loitering or prowling and willful obstruction of an officer from November 30th, 2022. The second case you have is 23 CR 2593D, in which you are accused of simple assault, family violence, and criminal trespass from a May 5th, 2023 incident. You have 2 subsequent bench warrants from these 2 underlying cases. Bench warrants are 23 FTA 985 from August 1st, 2023, and 23 FTA 986 from August 1st, 2023. With regards to the 2 underlying cases and the misdemeanor charges, you are legally presumed innocent of these charges, and upon your entry of a not guilty plea to both these cases, they will be scheduled for trial. At the time of the trial, the prosecution would have the complete burden to prove all the misdemeanor charges against you beyond a reasonable doubt. If the prosecution prevails, you could be convicted of 1 or more of these offenses and face a sentence of up to a year in prison and or up to $1,000 fine for each convicted offense. The sentences could be served separately or they could be served together, that is concurrently. Given this information, how do you plead to the 2 cases I've listed?
Not guilty.
All right, sir. Please understand that the bench warrants are for failure to appear, and you do have bonds already set for those cases.
Yes, ma'am.
All right. And so the cases will be scheduled for trial, and you will receive notice at the jail, or if you bond out, you will receive notice at your current mailing address. If your mailing address changes, please be sure to let us know. Ms. Adams, anything else to address with respect to these 4 cases?
Your Honor, we would like to discuss bond briefly. It's kind of unclear as to how much is bonded. I did see 9,000. I do believe one of the cases is for $4,000. The other one is for $5,000. Mr. Flowers is actually receives disability. He was shot a few months ago 3 times. He has a colostomy bag. He is from Georgia. His whole family is here. He's a very active father, Judge, with his 11-year-old son, whose birthday is actually tomorrow. Your Honor, we are in fact requesting he receive a signature bond on these charges. He does have a felony case where he does not have bond on those, and so he's not likely to be going anywhere until that matter is handled. And so, Your Honor, we are asking that he receives a signature bond in this case. Also, to Your Honor, with regards to contact, again, because he is an active father with an 11-year-old son, he shares with the complaining witness. He also, I did want to just go ahead and preemptively let the court know that he is legitimized.
Okay. Ms. Dunlap?
Thank you, Your Honor. So I'll start with position 5. This officers observed the defendant and another individual at 6129 Old National Highway in South Fulton. That's a Chevron gas station on November 30th, 2022. The officers advised the defendant to leave the premises. The defendant walked up to the officer's car, asking why he had to leave. Officers indicated that he was loitering. Defendant then stated he doesn't have to leave. Then he went into the store. Officers went into the store after him and asked him to leave again. He said that he wasn't leaving. He was going to buy some chips. Officers gave the defendant 5 seconds to leave. He then grabbed the defendant and attempted to take him out the store. Defendant refused to comply. Officers had attempted to tase the defendant, but the tasing prongs didn't make contact with him and only his jacket. So officers had to call for another unit for backup to detain the defendant. The state is asking for his bond to stay the same. The previous recommendation was, this recommendation would have been 12 months probation, 18 days, credit for time served 9 days, balance suspended, stay away from 6129 Old National Highway in South Fulton, the Chevron gas station. And the count 2 on the willful obstruction would have been 12 months probation concurrent with count 1, as well as the bench warrant in relation to position 5 was position 7, and we were going to enter at NP on a plea to position 5.
Okay, and Ms. Tyson, could you let me know about his recent arrest and his prior felony conviction?
He has a pending case. I can give you the case number. One moment. So the pending case is 23 CP 223036, and that was his last arrest. It was for receipt, possession, or transport of a firearm by a convicted felon, by receiving stolen property, and escape. He has one felony case he received first offender treatment on, in 2012. It was for a burglary and possession of tools for commission of a crime. He received first offender treatment, and that case was sealed July of 2017. And his most previous arrest was in Clayton County, and that was for a violation of probation. And in total, he has 5 violations of probation.
Right.
Nothing to add, Your Honor.
Your Honor, if I may,
You may.
I meant to mention that I did speak with Deanna Young yesterday, and she did provide that she does want contact.
Understood. So the original charge, the trespass, one of the charges against Mr. Flowers was loitering and prowling from November 30th, 2022. And then the subsequent case, the earlier case was simple assault, family violence, and that's a family violence case, and that's from May 2022. And now Mr. Flowers has been arrested with firearm charges, and in light of the fact that he's also got a background of family violence charges, that doesn't really add well to the mix. So I'm going to maintain the same bond, and we will further notice both cases for trial. Thank you.
Thank you, Your Honor.
Position 42, Wilbur.
And I have Miss McLeod who's joined the Zoom. So Deputy Francois, if
Yeah, I was gonna have him go next.
all right, appreciate it. Thank you. And this is Miss Woodbury's client. I believe she said it was position 42, Richard Wilburn, correct?
Yes, Judge.
And I'm going to waive sounding on the charges, please. Let me just go ahead on this one. And please, everyone, remember, I am waiving sounding on the charges. Unless you want to do a breakout, then I will be glad to do that. Any objection to waiving sounding?
No, Your Honor.
We don't object to waiving sounding of the charges, Your Honor.
Thank you. This is 23 CR 5382F. Mr. Wilburn is accused of 2 misdemeanor offenses, including criminal trespass from September 6, 2023. And Mr. Wilburn, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Rose Woodbury. Ms. Woodbury, what are we doing this morning?
Judge, I had just filed a motion for bond reduction on this case. The bond is currently set at a $3,500 surety bond. He is not able to bond out. He's been in jail for 63 days. And to my knowledge, this misdemeanor case is the only case holding him. He does maintain his innocence to these charges. So Judge, he's 62. He's been in the Atlanta area since the 90s. He does have a brother and sister in Lithonia, but he is disabled. He is homeless. Judge, we were able to get a housing placement for him at an organization called Epic Conclusions. This is an organization that provides transitional housing for folks, and the director of the organization, Eric Heflin, actually met with Mr. Wilborn and accepted him into the program. So we're asking the court to consider a signature bond today. The case is set for trial on the 27th of this month, but given the time he's spent in custody and the conditions at the jail and the fact that we have a placement for him, we're asking the court to consider a signature bond today. Thank you.
Just 1 second, Ms. Falk.
Yes, Your Honor. And I do have some concerns in regards to this case because it was reset before Judge Richardson for a jail jury calendar on September 21st of 2023. So, and a motion for bond modification was filed before Judge Richardson. So I am a little confused at why this is coming back before SAP, being that the defense asked for this to be reset to Judge Richardson's courtroom, and this case is now under Judge Richardson's jurisdiction.
Under the procedural history of this case and rereading the warrants and the bond orders, the bond modification is denied. This case is going to be set for trial on November 27, 2023, before Judge Eric Richardson, and that concludes this hearing. Thank you.
Yes, Your Honor. Thank you for your consideration.
No problem. Thank you. All right. Ms. McLeod?
This is going to be Ms. McLeod's case for just position 25, Ramsey.
Okay. But she has two cases, right?
No, I have one of those.
I have not had a chance to speak with Mr. Ramsey yet, Your Honor.
Okay. Ms. McLeod, would you be able to call the jail at 404-612-2392?
612-2392. Yes, Your Honor.
And that should give you access to speak to your client. Okay. And did you have two cases with us?
I do, Your Honor. I did not realize that Mr. Montgomery was on. I did speak to him a couple of weeks ago. I went to see him in Union City, but I still feel like I need to speak to him again, just to make sure that it's been 2 weeks, that he still feels the same.
Okay, Sergeant Smith at South Annex, that's Mr. Montgomery, if I'm not mistaken.
I have paperwork.
Nobody got it.
Is that correct, Sergeant Smith?
Probation officer, the city.
So the probation officer don't even be in court.
Sergeant Smith?
Yes.
Sergeant Smith, is that Mr. Montgomery next to you?
Yes.
All right. And how would his attorney, well, I guess we'll put the both of you in a breakout once she's done talking to the case at the jail. Okay?
Your Honor, could you please tell me the number for the jail again? I have 404-612.
2392.
Thank you, Your Honor.
All right. So Ms. McLeod, your process is you're calling courtroom 2, then you will go into a breakout with South Annex. Okay?
Yes, Your Honor.
All right. Thank you, Sergeant Smith. Please hold and mute your screen. Courtroom 2, do we have a case with either Ms. Adams or Mr. McLean?
Sorry, who's this? I'm sorry, what was that name again, Your Honor?
I'm just looking to address any case in which you have a client or Miss Adams has a client. I do still see a couple of people seated back there.
The only cases we have left in courtroom 2, Judge, is going to be Kilpatrick, which is 20 and 21, and then Ramsey, who's on the phone with Miss McLeod. And then the rest of the cases are going to be on the floors.
Okay, so who is representing Kilpatrick?
That's Miss Adams. She's talking to her client now, Judge.
Okay. All right. Which client is she talking to?
That's gonna be Kilpatrick, positions 20 and 21.
No, who is she? Oh, she's still talking to Kilpatrick?
Yes.
All right, please let her know we're ready for Mr. Kilpatrick. You know, I hate to waste time, so I'm just going to go down this calendar and see what's going on. Mr. McLean, do you happen to be available? Positions 23. Okay.
Your Honor, if I may make one quick interjection. I'm
Yes.
Attorney Pulliam for position 38, Leonard Watson. I also set him down for a bond reduction.
Okay. I don't know where he is, but let's see what's going on, okay? I'm just going to go over Mr. McLean's cases while I'm waiting for Miss Adams. And maybe your cases would be involved as well. Position 23 and 24, which was Logan, we've already addressed those.
Well, Your Honor, we're waiting to hear from, there was gonna be an iPhone call from another floor to one of these phones, and I haven't received that call yet.
Brandon Logan, are we going to move forward with that case?
That's what I was gonna ask him, Your Honor, whether he would like, whether he wanted to go to a plea position instead of the bond request position that we were in.
Okay. Position 25 and 26 is Miss McLeod. Okay, positions 27 through 33 are reset to Thursday, November 9th. Position 34 and 35, Mr. McLean.
Your Honor, that requires a social worker visit before to Mr. Shelton before we move forward. I'd like the social worker to ask certain questions and also discuss with me after meeting him certain impressions.
Okay, when do you want to reset this pending a social worker visit?
We do have a social worker here today, Miss Williams, so we can accomplish this today depending on whether we can access him in a timely manner.
Okay.
I have excuse me, Judge, I have an announcement on that part, but the elevators are not working, so that person may have to stand down.
That does affect things if the elevators aren't working.
I can reset it to November 14th.
We can try a breakout room or a phone call.
All right.
I had
So,
him
I'm putting a question mark, otherwise it's November 14th, okay?
Very good.
Position 36 is I think we've already done that one. No,
Not yet, Your Honor.
Tremaine.
26 is Pierce. How do we pronounce the last name? Tremaine?
Tremaine.
It's spelled kind of funny, but I think it might go with Tremaine anyway.
Excuse me, Judge, I don't mean to interrupt. We do have Miss McLeod's case back. They're ready.
Okay. So Tremaine is still waiting on a plea, and 37 was reset November 21st. And I'll go to 38, 39, and 40. I have a negotiated plea. 41 is null pros. I guess if you take a plea. Okay, I'm going to go to Miss McLeod's cases then. Miss McLeod, which one are we addressing first?
We are going to address Mr. Ramsey first, Your Honor.
Okay.
It's going to be a negotiated plea.
Okay, and he is in courtroom 2. All right. This is 23 CR 6681Y, State versus Roger Ramsey, accused of battery, family violence, first offense, willful obstruction of a law enforcement officer. And Mr. Ramsey, you've been advised of your right to remain silent. Your attorney is Ms. Maureen McLeod. This is going to be a negotiated plea. If you mind, I'd like to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation is on count 1, 12 months probation, serve 30 days in jail, credit for time served 15 days from October 20th of October 23rd of 2023. Balance suspended, stay away from 692 Westlake Court, Northwest Apartment B. No further contact with Andre Lott, 40 hours of community service and FVIP. On count 2, the recommendation is 12 months concurrent with count 1. The state is asking the defense to stipulate to venue, factual basis, and identification.
We do so stipulate.
All right. Just to clarify, Ms. Falk, I don't know whether you misspoke. You said balance suspended. Did you mean balance probated?
I did mean balance probated, Your Honor.
Okay, thank you.
Does that mean I don't have to pay anything, right?
Mr. Ramsey, you have a right to remain silent. Anything you choose to say, your statements could be used against you. But if you have a question for your attorney, you need to let us know that.
Yes, ma'am. I just, may I ask my attorney, does that mean that I just don't pay for the probation? I'm good to go?
Are you asking about probation fees?
Yes, ma'am.
All right, you pay probation fees for every month that you report if you decide to accept this plea offer.
Okay, all right, that's fine.
All right. Ms. McLeod, did you want to follow up with that?
Yes, Your Honor. I would ask the court if his probation could be suspended once he has completed the community service and the FVIP.
Any objection to non-reporting instead of suspension?
State has no objection to non-reporting after all of the conditions have been satisfied.
Okay. I will not suspend the probation, but I can convert it to non-reporting once all his conditions are completed. Is that acceptable?
Yes, Your Honor.
Right. Mr. Ramsey, that means that once all your conditions are completed, then your reporting to probation will be switched to non-reporting, which means you don't pay probation fees after that.
Thank you very much.
All right. So I'm still proceeding. And Ms. McLeod, do you stipulate to the factual basis, venue, and ID?
I do, Your Honor.
All right. Mr. Ramsey, have you consumed, I'm sorry. I think I did place him under oath. I did, didn't I?
Yes, ma'am, you did.
Okay. Mr. Ramsey, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Very satisfied.
And is anyone forcing you or inducing you to take this plea offer today?
No, ma'am.
And Mr. Ramsey, has it been explained to you that if you decide to plead guilty to these charges, that you will have a guilty conviction for battery, family violence on your record, which means that if and only if you ever get arrested for the same or similar offense, that it will automatically be a felony charge.
Oh, my goodness. So, okay. Yes, ma'am.
Do you understand that?
When I complete probation, can you take it off my record? Is that a possibility?
No.
Okay, all right, I understand.
Are you still willing to move forward?
Yes, ma'am.
And also, if you decide to plead guilty, you will be giving up your constitutional right to have a trial in front of a judge or a jury. You will not be able to go back to court, have the assistance of counsel to confront your accuser, challenge the witnesses and the evidence which may be presented against you, to have the opportunity to present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence?
I mean, honestly, I really plead. All right, I plead guilty.
I'm so sorry.
Yes,
You
ma'am.
were wavering on that, Mr. Ramsey. If you have any question about whether you want to plead guilty, please let us know now, because I do not want you to give up your right to challenge this charge in a court of law. If you don't feel that you are guilty of this offense and you're just doing it to get out of jail, that would not be a sincere plea of guilt. So if you want to challenge this charge in a court of law, if you want to exercise your constitutional rights to have a lawyer assist you in
Oh,
challenging.
ma'am, I plead guilty.
All right, you're pleading guilty to battery, family violence. Would that be correct?
Yes, ma'am.
How do you plead to one count of willful obstruction of a law enforcement officer?
I plead guilty.
Your sentence on the battery charge is 12 months to serve 30 days in jail, credit for time served 15 days. So if you have no other cases holding you at the jail, then you should be released within 24 hours. Once released, your case will be placed on probation. You will report to the probation office next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete 40 hours of voluntary community service at any nonprofit agency. You must begin your community service within 60 days of being released. You will also attend and complete a 24-week domestic violence intervention program, and you must enroll in those classes within 60 days of being placed on probation. You're also to stay away from 692 Westlake Court in Northwest Atlanta, the entire complex. You have to stay away from the entire complex and especially apartment B, and have no contact with Andre Lott, L-O-T-T. Once you have completed the 40 hours of community service and the domestic violence classes, then your probation may convert to non-reporting, in which then you won't have to continue to report and pay probation fees, but you are technically still on probation.
Yes, ma'am. I would need to get my belongings also, because I got all my, I stayed there and I lived there and I was renting a room. I was renting a room out of the apartment, so I would need some, I do need to gather up my belongings. Like, I got maybe like 10 cell phones, maybe like 2 laptops.
I will allow you a one-time visit.
Right.
That visit must take place within 14 days of being released.
What's going to take place as soon as I hit the door?
The visit must take place within 14 days of being released. And you must visit, you can go to the location with a police escort. You must go to the local precinct and let the police know that the judge has authorized you to do a one-time visit, but you must be escorted by a police officer. That visit cannot exceed 1 hour.
Okay.
All right. After that, you need to stay away from that entire complex.
So, okay. Now, my other girlfriend stayed right in the same location. So I got to move out the whole complex, even if my other girlfriend stay in the same area.
She can visit you. You cannot visit her while you're on probation.
I mean, another girlfriend that stayed at the other girl.
Gee, I don't know whether you wanted to broadcast how many girlfriends you have, but whoever lives at the complex, you cannot visit them. They can visit you outside the complex.
Okay, all right.
Your Honor, my client was asking because he had planned to go and stay with the mother of his child, who also lives in
Stay
that
away from the entire complex.
So my mom, my baby mom, she lives at a whole nother address.
Is it in the same apartment complex?
No, ma'am, it's a house. That's not my baby mom, the one that I got in the situation with. That's my ex-girlfriend. I was going to go stay with my baby mom.
You can stay with whoever you please as long as it's not Andre Lott and is not within 200 yards of the entire apartment complex at 692 Westlake Court.
Yes, ma'am.
Does that clarify it, Ms. McLeod?
It does, Your Honor. Thank you.
Thank you. All right, that concludes this case.
Yes, Your Honor. I do need to speak to Mr. Montgomery briefly because I spoke to him over 2 weeks ago, and I just want to talk to him again.
Ms. Champion, if you could place Ms. Maureen McLeod in a breakout and Sergeant Smith at South Annex, you will see a message on the screen to join a breakout.
In medical, we have position number 22.
Okay. That would be Secondi Landry.
Yes, ma'am.
Mr. McLean or Miss Adams? All right, we have Secondary Landry, 23 CR 1769G, accused of two counts of theft by taking from March 22nd, 2023. Mr. Landry, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Miss Samantha Adams, who is located in courtroom 2. Do you see her on the screen?
Yes.
All right. And Ms. Landry, with regards to position 22, this is going to be a arraignment and a bond modification request. Would that be correct?
Yes, Your Honor.
Do you waive a reading? I see a waiver of arraignment was already filed on April 6, 2023. So the case has already been arraigned. His bond was set on March 23rd, 2023, and that was for a $2,000 good bond.
Yes, Your Honor. Also, too, Your Honor, I would like to point out that he also that the state provided an add-on case, which is case number 19 CR 007624 G as in girl.
I do see that case. It's not on the calendar, but I do see his other open case. And in that particular case, he's accused of theft of lost or mislaid property, reckless conduct, and misdemeanor possession of marijuana. It looks like a waiver of arraignment was filed on June 13th, 2023. And
Yes, Your Honor. He would like to just go ahead and move forward with this not guilty plea and
both cases? Okay, both have been arraigned.
yes, Your Honor. We would like to do a bond request on them.
On both of them? Okay, on the 19 CR case, his bond is presently, looks like it's a $1,000 bond. Has that changed?
Your Honor, he's not in custody on the 19 CR case. The only reason the state added it was as part of a global resolution.
Oh, okay. All right, so then we are back to the 23 CR case.
Yes, Your Honor.
And what's the bond modification for that? He's got a $3,000 good bond. Oh, sorry, $2,000 good bond.
Yes, Your Honor. Would you like me to go ahead first?
Go ahead.
Okay. Yes, Your Honor. Mr. Landry, he was born and raised right here in Georgia. His education goes, he has some of a college education. He completed some time in college. He was gainfully employed at State Farm Arena for setting up for shows. That job is kind of sporadic. However, Your Honor, he does have his whole family that lives here. He does have a good address, and also too, Mr. Landry, even though his bond is set at $2,000 for this case, he's served about, and they can correct me if I'm wrong, but what I could see is he served about 229 days. And so with regards to that, Your Honor, we are requesting a signature bond. Oh, and furthermore, Judge, he does have a child, a 3-year-old. And so we are requesting a signature bond.
This is Secondia Landry, right?
Yes, Your Honor.
Okay. And you do understand that he's got another matter in Superior Court?
Yes, Your Honor.
Okay. Ms. Falk, without sounding out that particular charge, anything else with regards to bond recommendation for this particular case?
So a couple of things, Your Honor. First, this case has already been reset jail jury before Judge Mather back in April, which is why there's a waiver of arraignment. So to come back for a bond modification when the case is before Judge Mather is a little unusual in those circumstances. Additionally, this defendant is currently in custody on that charge on a no bond on 23 SC 1888234. As well as a $50,000 surety bond on a battery charge. So he is not going anywhere based on these charges. I will state the defendant has an extensive history. Going through his history, he is a multi-state offender. He has cycles in both Georgia and in, let's see, he has cycles I misspoke. He has cycles in Georgia. It does not appear he is a multi-state offender, but he does have numerous cycles in Georgia. He has a total of 18 cycles. He additionally has convictions for possession of marijuana, for theft by shoplifting, for, let's see, failure to appear in 2019, and for sexual battery in 2021. He also has a failure to appear in 2020, a disorderly conduct, a criminal trespass conviction in 2021, and it appears an arrest for robbery and battery out of Clayton County in 2021. For all those reasons, we believe the bond should remain the same. I am placing on the record that the defendant has, the recommendation on the defendant's case on the calendar was 230 days, credit for time served 230 days, which was a time served plea. We are revoking our recommendation.
Ms. Adams, I'm just looking at the notes also set by the judicial officers in the Superior Court matter. At the present time, there's clearly an intent to not reduce his bond, and they do deem him to be either a recidivist or a threat to the community. So I am not going to grant a bond modification. Thank you.
Thank you, Your Honor.
I have a couple of, Ms. McLeod, are we ready to address your client at the medical unit? And then we will address Mr. I think it was Mr. Logan at the jail court. Ms. McLeod?
Yes, Your Honor.
And what was your client's name again? Was it Montgomery?
Javaris Riley Montgomery, Your Honor.
All right, thank you.
And Your Honor, if I may ask that Ms. Dunlap be excused at this time, she has class.
Okay. Sorry, you can't play hooky, but you're off. Thank you. All right. I'm trying to, I don't know why I don't have Mr. Oh, I do see him. Okay. This is State versus Javaris Riley Montgomery, case number 23 CR 58939A. 58398, accused of reckless conduct from May 11th, 2023. And Mr. Montgomery's located at the South Annex. Ms. McLeod, he has been advised of his, well, I'd like to advise him again of his right to remain silent. Anything that he says in open court, his statements can and will be used against him. He has a right to an attorney, and Ms. McLeod's representing him. So, Ms. McLeod, how are we moving forward with this case?
Your Honor, he needs to be arraigned. He will not be accepting the state's plea offer.
All right. Do you waive a reading of the accusation?
I do, Your Honor.
All right. Mr. Montgomery, I've already indicated the charge has been brought against you. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution would have the burden to prove the charge against you beyond a reasonable doubt. And if they do prevail, you would be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
I guess.
All right. I'll accept your not guilty plea, and the case is arraigned and is going to be further notice for trial. Thank you very much. Sergeant Smith, did you have any other cases with us?
Oh, thank you.
All right. Thank you for your patience. Take care.
Thank you. That concludes my business before the court. May I be excused?
Yes. Thank you, Ms. McLeod. All right. Mr. McLean, we have your client at the jail court. And how is he proceeding? You're on mute, sir.
We still need to receive a phone call to 404-612-2392. It'll be pretty brief, I think.
Deputy at jail court iPhone, could you please call courtroom 2? Do you have the number?
Yes, I have the number, yes.
All right, appreciate it. Thank you.
Thank you.
All right, please mute jail court iPhone. Courtroom 2, who do we have, please?
2021 Kilpatrick.
All right, This is State versus Terry Kilpatrick. And Mr. Terry Kilpatrick has two cases before us. Mr. Kilpatrick, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Samantha Adams. The first case is 23 CR 4261J, in which you have 2 counts of terroristic threats and acts and disorderly conduct from October 30th, 2022. Your second case is 23 CR 6290J, in which you're accused of simple assault, family violence from October 18th, 2023. Ms. Adams, how are we proceeding in both cases?
Since he's not guilty and a bond request, Your Honor, I believe he has bond on, I believe he has, yeah, it'll be a bond request, Your Honor. I'm not sure if he has bond on one of them, but I do know he, we would like to be requesting a modification on the other one where his bond is $1,000. I believe that's position 21 that he has a bond on.
On the position 20, in which he's got 2 counts of terroristic threats and disorderly conduct, he made bond on September 16, 2023. With respect, with respect to the recent case, he's got a presently he's got a bond issued on October 18th for $1,000 with a stay away from Alexis Stevenson. All right, and Miss Adams, what's the purpose of reducing the $1,000 bond?
Mr. Kilpatrick also has, I believe, felony pending, and so he's not gonna, he doesn't have bond on those. He's been in here with the $1,000 bond, and it hasn't been paid yet. And so as a result of that, in addition to the fact that he's currently in trade school, he's gainfully employed, he has 3 children, he does, and he's a very active father. Your Honor, it has also been brought to our attention that the complaining witness does not want to move forward based on what she went to the solicitor's office and filled out an affidavit. Your Honor, so we are asking for a signature bond in this case so that he can go ahead and number 1, focus on the felony case, and also 2, he does want to handle this case because he does maintain his innocence.
Does he have a bond in that other case?
No, Your Honor, he does not.
All right, Ms. Falk.
Your Honor, just to put on the record briefly, he actually was given a pretrial services bond on that 23 CP 219186 case. That bond was then surrendered by pretrial services. So that is currently also what is holding him in the jail. Based on what I'm seeing, that 23 CP case involved looks like willful obstruction, criminal damage to property in the 2nd degree, cruelty to children in the 3rd degree, and I believe there was also a battery charge. I'm trying to actually locate the battery charge on that case.
The booking was for battery and criminal family violence and
correct.
Okay.
And so there is a repeat of the behavior here, which it does give a rise to a risk of reoffense in our case. Also looking at his general history, if Your Honor could give me a moment, the defendant was alleged in, and we are only addressing, I guess, the family violence, excuse me, the simple assault family violence case. In that case, Your Honor can just give me a moment. In that case, it is alleged that the defendant, through a black pot cover and humidifier, Miss Stevenson advised that she picked up a screwdriver in order to defend herself from the defendant. And while she was exiting the apartment, he threw a black pot at her, which is the basis for that arrest. The defendant also has a number of cycles on his history. We're looking at a arrest from 2011, a simple battery disorderly conduct where he was convicted of the disorderly conduct in 2013 in DeKalb County, theft by shoplifting in 2013 in DeKalb County, a simple battery where he failed to appear in 2014, a family violence battery, which was reduced to a simple battery family violence. What's interesting there, that was out of Douglas County, July 13th of 2023. He was ordered to be on probation for 12 months, have FVIP and no violent contact with Alexis Stevenson. Given that this case occurred in, let's see, October 18th, 2023, that would be both a violation of his probation in Douglas County, but a violation of the terms that he have no further violent contact. For those reasons, we're asking that the bond remain as set, and the state is withdrawing our recommendation of 12 months, serve 45 days, credit for time served 21 days from October 18th, 2023. We were also requesting balance probated FVIP, 40 hours community service, and no contact with Alexis Stevenson.
Any counter, Ms. Adams?
Yes, Your Honor. With regards to Ms. Stevenson, she is the mother of his children. I'm not sure who the minor child or children are in the cruelty to children charge that he has. He also maintains that, aside from the fact he does have a presumption of innocence, I understand that he has been convicted of simple battery with regards to Ms. Stevenson. But the way that the facts are alleged against my client, Your Honor, that's not at all how it happened. And so additionally, Judge, part of the recommendation, I also wanted to throw in there from the state was to stay away from 3000 Continental Colony Parkway, apartment F169. That's actually his home. Ms. Stevenson does not live there. And so if he does bond out on this charge, if he's able to get the things taken care of with regards to the pretrial and the felony, we would like for him to be able to return home.
Okay.
Regardless if the court gives a signature bond or if he's able to bond out on this charge. I'm trying to see.
Signature bond is a privilege, not an entitlement.
Yes, Your Honor.
And unfortunately, he's already violated a prior signature bond that was revoked pursuant to this, hence due to arrest. So the $1,000 bond is the lowest that we can go on these misdemeanor offenses.
Yes, Your Honor.
Bond modifications denied. Case is further notice for jail jury.
Yes, Your Honor. Your Honor, I do have a question. If he does make bond, I'm not sure what the bond condition was because I wasn't able to see it. I guess I'm having issues with my Odyssey, but was there a stay away from that location?
Right now, there's a stay away in that bond order. I'm trying to remember Judge Mincy's order, Judge Williams. Yeah, there was a stay away from 3000 Continental Parkway. He does have a one-time escort to verify residency. So if she doesn't live there, then he can go back into the location. But if she lives there, he cannot return to the location.
Okay, thank you, Your Honor.
That's police call.
Yeah.
All right, please mute your screen while you're speaking to your client.
Yes, Your Honor.
Medical, is that Mr. McLean's client?
Yes, this is Johnson. No, I think it's Miss Adams' client.
Yes.
Position 17 and 18.
No, that's Miss Adams. Okay.
Ready, Your Honor.
They just call and then when I hear about them, they just kind of okay.
All right, this is State versus Samuel Johnson. And Mr. Johnson has two cases before the court. On position 18 is one charge of criminal trespass under accusation number 22 CR 4038Y from a February 21st, 2021 incident. The second case is position 17, and that's a bench warrant for failure to appear, and that's 23 FTA 978 from May 16th, 2023. Mr. Johnson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Samantha Adams. It appears this is going to be a negotiated plea. Are we still pursuing with the plea?
Yes, Your Honor.
Okay. Mr. Johnson, please raise your right hand and unmute medical unit. If the medical could please unmute. Medical, could you please unmute? Thank you. Mr. Johnson, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on this case is 12 months probation, served 24 days, credit for time served 12 days. That is from October 27th, 2023, balance suspended. Stay away from the Chevron at 639 Morosco Road in Atlanta, Georgia. The state would ask the defense to stipulate to venue identification and factual basis.
So stipulated. Mr. Johnson, you can put your hand down.
All right. And Ms. Adams, have you spoke to your client and does he accept the terms?
Yes, Your Honor.
All right. Medical, if you could unmute again, I need to ask Mr. Johnson some questions. Mr. Johnson, have you consumed any medication or alcohol recently? Could you please sit up straight because there's a lot of noise in your background. So if you can get closer. Sit up straight. Okay. And have you consumed any medication or alcohol recently?
No, I think it's a tuberculosis.
All right. And after consuming that, are you still able to understand the proceedings?
Yes.
Are you satisfied with your attorney services?
Yes.
And is anyone forcing you to take this plea offer today?
No.
Has it been explained to you that if you decide to plead guilty to criminal trespass, that you would be giving up your right to go back to court and have a trial, to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yeah. Yes, ma'am. Yes.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 24 days. Credit for time served 12 days. The remainder of the time will be suspended. If you have no other cases holding you at the jail, you'll be released within 24 hours. You must stay 200 yards away from the Chevron gas station at 639 Morosco Road in Atlanta, Georgia. You cannot be at the station. You cannot be in its store. You cannot be at the parking lot, at the sidewalks. If you are seen anywhere near that location, we will have you arrested for trespass again. Thank you. Oh, and the FTA is null prost. Thank you, medical. Did you have another case?
Yes, I have position number 34 and 35, Shelton.
That would be Mr. McLean. Is he available?
All
right, courtroom 2. Mr. McLean? If you could unmute courtroom 2, please. All right, we have Maurice Shelton Jr. accused in 2 separate cases. 23 CR 3551B of battery family violence and 6663B of battery family violence. Position 34 is from a June 2023 incident, and position 35 is from an October 2023 incident. Mr. Shelton, you have a right to remain silent about the facts of the case. Any statements you make can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, I believe this was the one we were holding for a social worker visit. Do you have the status?
That is correct. It is one of those. I think there were about 2 or 3 in that category. Mr. Shelton, Mr. Maurice Shelton has a family in Americus, Georgia. And he has certain things going for him in the way of expectations of treatment, which we are going to seek in the next several days to get started, to be followed up on. The offer from the state, if it could be held open for a while, we are trying to see about the MH aspects of this case and the correct treatment. So we are not ready to go forward with a plea today. It does involve an extra time offer. And we realize that is simply a recommendation, but if it pleases the court, this would be appropriate for a reset of perhaps 2 days or 7 days.
I can reset it to the July 16th, 11 a.m. calendar if,
Not July.
I'm not July, excuse me. What am I thinking? November 16th, at least I got the date correct.
Yes.
November 16th, 11 a.m. calendar.
And if there's some progress, we'll try to alert the court before then.
I don't know if this person, Cindy iPhone, is a relative.
That's the alleged victim in the case, Your Honor.
All right. Positions 34 and 35 are reset to November 16th at 11 a.m. Pending the defense possibility of finding placement for treatment or any other recourse. Thank you.
Thank you.
Thank you, medical. May we have our next case?
By the way, Your Honor,
Position 23 and 24, Logan.
I was about to say that is going to be a plea, Your Honor. Hopefully the state is okay with a pause in what we were doing.
Ms. Falk, are we ready to proceed with the plea for position 23? And I'm assuming you're in a null pros 24?
That would be correct, Your Honor, and we're prepared to go forward.
This is State versus Brandon Logan, case number 23 CR 4225B. Mr. Logan has been advised of his right to remain silent. His attorney is Mr. McLean. And Mr. Logan, if you place your right hand up, please, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's the plea offer for Mr. Logan?
Yes, Your Honor. The plea offer is 12 months probation, serve 18 days, credit for time served 9 days. That was from October 30th, 2023. Balance suspended and a stay away from 4330 Fulton Industrial Boulevard. The state would ask the defense to stipulate to venue, factual basis, and identification.
For the purpose of the plea, we do so stipulate. I believe he knows what that address is and will stay away from a Hilton.
Did you say the Hilton?
No, Fulton Industrial Boulevard.
Oh, okay.
Right. It was an abandoned building. I don't believe we have a name.
All right. Mr. Logan, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anybody forcing you to take this plea offer today?
No, ma'am.
Are you doing this freely, willingly, and voluntarily?
Yes, ma'am.
So you're not doing it just to get out of jail?
No, ma'am.
All right. And Mr. Logan, if you decide to plead guilty to this charge, you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury. You will not be able to confront your accuser, challenge the evidence brought before you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty, Your Honor.
Your sentence is 12 months to serve 18 days, credit for time served 9 days, balance suspended. If you have no other holds at the jail, the bench warrant matter is going to be null pros, so that's not going to hold you at the jail. But if you have no other cases holding you, you'll be released within 24 hours. You cannot return to 4330 Fulton Industrial Boulevard, that building. If you have no rightful authority to be at that location, you cannot return to that location. Do you understand, sir?
Yes, ma'am.
Otherwise, we get to do this rodeo all over again.
We won't.
All right. Thank you, sir. You're free to go.
All right, thank you.
Position 36, Jermaine Pierce.
That is also mine, Your Honor.
All right, sir. I'm confused. What was that position number?
36.
36, thank you.
36.
Miss Adams, Mr. McLean, this is going to be an arraignment.
I believe this will be a non-negotiated plea, Your Honor.
Oh, you're right. Sorry about that. Why did I think it was an arraignment? Okay, sorry about that. Okay. This is State versus Pierce Tremaine, 23 CR 5918F. Mr. Tremaine was accused of battery from a September 9th, 2023 incident. Mr. Tremaine, you have a right to remain silent about the facts of the case. Anything you say can and will be used against you. You have a right to an attorney, and your counsel is going to be Mr. Mike McLean. A non-negotiated plea means that the prosecution is going to give me a recommendation, and then your attorney is going to give me an alternative recommendation. Based on the circumstances of your case and your prior history and any other factors, I will let you know which recommendation I will accept before we proceed with the plea. Ms. Falk?
Yes, Your Honor. This incident actually happened at the MARTA station. The location of the MARTA station in question was at Art Center MARTA station, located at 1255 West Peachtree Street. Law enforcement was dispatched to that location. They made contact with Mr. Rady Williams, who had a cut to his lip, blood stains all over his shirt. He was quite disoriented initially from the attack, but he did inform the officer that a black male had struck him. He also stated that the male was wearing all black with a mask on, walking with a bike, and had a black backpack. While waiting from Grady, Mr. Williams was able to state that he was attacked by this defendant, and he was unable to remember really anything else. So MARTA CCTV, they looked at the MARTA CCTV. The footage showed the defendant punching Mr. Williams in the face, and then backtracking it, they were able to connect it with his card, which showed that it was the defendant, Rady Williams. He was detained on October 3rd of 2023. Mr. Williams was actually taken to Emory University Hospital for the injuries he sustained from the incident, which included a upper lip laceration, which did take stitches to close. We have spoken at great length to Mr. Williams. He has provided us with that medical documentation that showed he had a laceration to his lip that did require stitches, as well as a $4,000 medical bill. We are going to ask for a restitution hearing on that. We are recommending 12 months to probation, serve 180 days. He would receive credit for time served 36 days from October 3rd of 2023, balance probated, 8-week anger management, 40 hours of community service, no further contact with Rady Williams, stay away from 1255 West Peachtree Street Northeast in Atlanta, which is the MARTA station. I would like to point out that initially this case was recommended to the DA's office due to the fact that not only did the victim have that injury to his lip, but also the fact that he maintains that his headphones, which were worth about $40, were stolen as a result of this incident. The DA's office declined to accept it as a felony aggravated assault or robbery, which is why we are proceeding today on this case as it stands. I will point out that I would like to sound for Mr. Rady Williams if he is here, but the thing that is proving most troubling for the state in this case is the fact that the defendant punched Mr. Williams, who he did not know, in the face. It was caught on video, as well as the fact that Mr. Williams' previous arrest was from March of 2022 for battery. So for that reason, we do have serious concerns that he has 2 cases on his history that both involve battery. We are asking for that recommendation. If we could sound for Mr. Rady Williams.
All right. Mr. Rady Williams. Ms. Tyson, do you have this gentleman's history, Mr. Tremaine?
Yes, Your Honor, that is correct with Ms. Folk stated. He has one previous arrest, and that is from March 16th of 2022, and it was for battery also. Nothing to add.
And Your Honor, I do just want to add, he was sentenced on that case by Your Honor on March 31st, 2022. And as part of that, he was he received 12 months, 45 days to serve, and 12 weeks anger management, as well as stay away from Atlanta Towers and no contact with Marixa Thomas. So again, would be his second conviction for a violent offense.
Do we know if he's completed probation?
He did successfully complete, and there was a successful termination of probation on April 11th of 2023 that was signed by Judge Porter.
All right. Mr. McLean, what's your recommendation?
Your Honor, for the purposes of the plea, of course, let me mention that he would stipulate to jurisdiction and factual basis and identification for the purpose of the plea. He's asking the court to consider a large break to him on the extra jail days issue. For the purpose of the plea, he would feel that he would state to the court that it's appropriate for anger management again. And even though the state has recommended 8, it would be appropriate in his opinion to go to 12. Your Honor, he understands the 40 hours of community service and is ready and willing to do that. Your Honor, he feels that it would be more appropriate to give him, because he is accepting responsibility for the purpose of the plea, to give him time served as the jail portion, or perhaps a week or a fortnight.
Anything else, sir?
Yes, Your Honor, I would. In the factual basis, I would mention too that there was an encounter that he's not offering as a justification. It's somewhat in mitigation. The defendant was using the bathroom and the other person came in and did not leave right away. There was a confrontation. It was unpleasant tension, created some anxiety, and he's not saying that that's an excuse for what he did, but nonetheless, that did happen moments before.
Yeah, I already read the warrant on that matter as well. I'm really very perplexed. So Mr. Tremaine just finished probation successfully, completed anger management classes, and then within a couple of months is right back to square one. I'm not certain if letting him out again to do anger management, or am I just recycling a recidivist? So at the present time, I am very, very comfortable accepting the state's recommendation, which would be to serve the extra jail time, to be on probation every month. And he is going to be on a complete ban from all MARTA facilities while he's on probation. And then of course he has the restitution matter that he has to address. So I'll be glad to take another hearing where Mr. Rady Williams will have an opportunity to appear and also present his medical bills to the prosecution in order to establish restitution. I think the state mentioned in excess of $4,000. So, Mr. Williams, considering that this is an extra time case, I can reset this to November. I think, would that give you adequate time if we reset it to November 21st?
Well, that's just one issue, Your Honor. He was putting up a non-negotiated plea, and I need to ask him, Mr. Tremaine, do you want to go forward today on this plea? You've heard what the judge leans towards.
We need to unmute medical.
I could have a breakout room if he needs to confidentially speak to me.
But please understand, I won't be taking the plea today. The plea will be addressed on the 16th or the 21st, either day where the documents need to be available to address restitution.
Understood, Your Honor. Of course, an alternative play would be to simply have a restitution hearing.
It's up to you. He can either plead out today with a reset to, No, I think I'd rather him still be in jail, and we will add the additional time to the thing. So reset date, 16th or the 21st.
Either date would be fine, Your Honor.
All right.
Think
Ms.
it'll-
Falk?
Yes, Your Honor, the 16th is fine for the state.
All right. This will be reset to November 16th. That will be handled by either Judge Morrow or Judge Mincy. Excuse me, Judge Williams, please let them know that this case is held open to address the plea offer if Mr. Tremaine still wants to move forward with the plea, as well as the restitution hearing. And Mr. McLean, please note that Mr. Williams would need to appear to authenticate his medical bill. All right, thank you.
Your Honor, is there a way that there can be a note placed on this case for whichever judge hears the case next, that this was in fact heard by Your Honor and Your Honor's
Yeah, I'll make a note on the Odyssey about that.
Thank you, Your Honor.
Okay, thank you. Next case, please.
Position 9, Hatcher.
All right, who do we have on the medical, please?
Position number 9.
Nine, that's Miss Adams' client.
Yes, Your Honor.
All right, sorry, it's a lot of paper shuffling around here. Okay. This is State versus Daquan Louise Hatcher, case number 23 CR 6676. I think 70J, excuse me. And he's charged with simple battery and theft by shoplifting from October 24th, 2023. With regards to position number 9, Miss Adams, this is going to be a negotiated plea.
Yes, Your Honor.
All right, Mr. Hatcher, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Miss Adams. Ms. Falk?
Yes, Your Honor. The state's recommendation is to count 1 as 12 months probation, served 30 days, credit for time served 15 days. That would be from October 24th, 2023 to today. Balance probated, no further contact with Benjamin Buchanan. Stay away from the Kroger located at 2452 Morosco Drive, Atlanta. Count 2 would be 12 months probation concurrent to count 1, served that 30 days, 40 hours of community service, $500 fine, anti-theft course, as well as the stay away, and count. That would be a total of 12 months probation, serve 30 days, credit for time served 15 days, balance probated, a $500 fine, anti-theft course, 40 hours of community service, no further contact with Benjamin Buchanan, and stay away from Kroger. I would like to note that the $500 fine and the community service is being requested as this is the defendant's 3rd theft by shoplifting conviction. Any subsequent theft by shoplifting convictions after this will make him a felony recidivist under the theft by shoplifting statute. State would ask the defense to stipulate to venue, factual basis, and identification.
Stipulated.
Right. If the state would please unmute medical. Mr. Hatcher, I don't think I placed you under oath. Do you solemnly swear and affirm the testimony provided will be the truth to the best of your knowledge?
Yes, Your Honor, yes.
Okay, and you can put your hand down. Mr. Hatcher, you've already heard the state's recommendation, and your attorney has stipulated to the factual basis, venue, and ID. Have you consumed any medication or alcohol recently?
None at all. No.
And have you understood the proceedings?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And do you understand that if you decide to plead guilty today, that this will be your 3rd theft by shoplifting conviction on your record?
Yes, Your Honor.
Any future arrests for this kind of offense will automatically be a felony charge.
Yes.
Do you know the difference between a felony charge and a misdemeanor?
Correct. Yes, I do.
And you understand the jail time and the penalties could be a lot more serious than a misdemeanor charge.
Yes, yes, Your Honor.
Are you still willing to go forward with this plea?
Correct. Yes, Your Honor.
Has it been explained to you that if you decide to plead guilty to these charges, that you will be giving up your right to a trial in front of a judge or a jury? You will not be able to have the assistance of counsel to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of theft by shoplifting and 1 count of simple battery?
Guilty.
Your sentence for the simple battery is 12 months to serve 30 days, credit for time served, 15 days. The remainder of the time will be on probation. If you have no other holds at the jail, you'll be released within 24 hours. You must report to probation next Thursday at 132 Mitchell Street before 3 p.m. While you're on probation, you are to have no contact with Benjamin Buchanan and to stay away from the Kroger store on Morosco Drive in Atlanta, Georgia. On the theft by shoplifting, you'll also be on probation. The sentence time is the same, serve 30 days, credit for time served 15 days. While on probation, you will complete 40 hours of voluntary community service. You must begin the community service within 30 days of reporting to probation. Again, and you also must complete an anti-theft class. The anti-theft class must be done within 60 days of reporting to probation, your first report. You must also pay a $500 fine, and you will have the remainder of your probation time to pay off that $500 fine. Again, also stay away from the Kroger. You've already been forewarned that this is your third shoplifting conviction. Please be on notice that any subsequent arrest will be a felony charge. Thank you.
Thank you. Thank you so much.
Give me a moment. I gotta go get position number 3 and 4, Dwight.
All right. Well, okay, please mute. All right. Courtroom 2, do we have anyone else that we have to address for SAP?
I don't think there's anybody else in here for SAP.
Okay. Just to go down the calendar, and Ms. Adams, you can advise me accordingly. Position 1, Banks 1 and 2 were arraigned and further notice for trial. Position 3, Patrick Dwyer.
That's
What's the announcement?
She went to go get him for
Okay, that's the
I do need to speak with him very briefly.
okay. All right. That will be for position 3 and 4, correct?
Yes, Your Honor.
Okay. Position 5 and 6 and 7 and 8 were arraigned, and that's further notice for trial. Position 9, Hatcher, was a plea. Position 10, Dustin Hayes is arraigned and further notice for trial. 11, Marquis Hood. What was the announcement?
That's a not guilty with the bond request, Your Honor. He waived appearance.
Okay. We have to address that too. And you'll be filing a waiver of arraignment on 11 and 12 since you are waiving his appearance?
Yes, Your Honor.
Okay. Ms. Grace, please make sure you get a waiver of arraignment for positions 11 and 12. Position 13, Eric Jackson.
Your Honor, our social worker is here to see him. He may be reset, but based on what she has to say is going to determine whether or not he needs to be reset to another calendar or to competency.
Okay.
And Your Honor, I have an announcement from the state on Eric Jackson. The DA's office has accepted that case as an aggravated stalking. So we will be sending, I just need Edie Hutcherson to sign the order, and we will be sending that over shortly.
Okay. I'm going to reset this case to November 14th, pending a transfer order submitted by the Solicitor General's office. Position 14, Dejuan, 14 and 15 and 16. Dejuan Jewel, what's the announcement?
Your Honor, Mr. Jewell has private attorney.
Do we know who it is?
Yes, Your Honor, his name is David.
He was released, Your Honor.
Oh, that was Mr. Schnipper. Okay.
Yes.
Yes, okay, we already addressed those. Okay, thank you. Samuel Johnson's position 17 is null pros, 18 was a plea, 19, Martavius Kemp.
Your Honor, I made an attempt to visit with Mr. Kemp. He refused my attorney visit yesterday. I'm not sure if he's gonna be appearing on in medical or on another location. If not, Your Honor, we're gonna request a reset.
A reset to November 14th. Position 20 and 21 Kilpatrick, that was arraigned and further notice for trial. Position 22 Secondi Landry, that was arraigned and further notice for trial. I think those were your cases, right, Miss Adams?
Yes, Your Honor. They
All
were.
right. All right. So let's go to 11 and 12, where you waived the appearance. I'm still waiting on medical. So this is Marquis Hood, 23 CR 1478C and 23 CR 5724C. Appearance has been waived by his counsel, Ms. Samantha Adams. Mr. Hood is accused of battery, family violence from December 16, 2022, and in position 12, accused of battery, family violence from May 14th, 2023. And I don't know if his arraignment has taken place. A waiver of arraignment was submitted on October 5th, 2023.
Right now, signed by Brandon Theater Thomas, and saying that
Both cases. Okay.
I'm sorry, Your Honor.
Waiver of arraignment was filed for Mr. Hood in both cases on October 5th, 2023. And both cases have been further noticed for jury trial, along with 2 other companion cases. What are we addressing today?
Fine, Your Honor.
she's dismissed.
In which case?
For both, I believe the total bond he has, total is $10,000. I think it's $5,000 on each case. Your Honor, we were just requesting that his bond, be lowered. He does currently have a felony case pending that he will have to handle along with the violation of probation. And so as a result to that, Your Honor, that's one of the reasons why we're requesting a lower bond. In addition, Your Honor, he was born and raised right here in Georgia. His whole family is here. He does have a child, a 5-year-old son. He has a GED, and his last job, he worked for Atlanta Moving, where he was gainfully employed. He has been incarcerated for about 47 days. And again, Your Honor, we're asking for a bond modification, a lower bond on those 2 cases.
I understand that, but presently I'm just looking at his booking information. He's in custody for 47 days due to a felony arrest. And the charges in there clearly indicate that Mr. Hood is has a very high likelihood to reoffend and is clearly a threat to the community. The bond request is denied.
Thank you, Your Honor.
Yes, medical, who do we have, please? And position 11 and 12 are further notice for trial, along with the 3rd open case. Medical, who do we have?
For Dwyer.
All right, this is Patrick Dwyer, case number 21 CR 002374B. Mr. Dwyer is charged with criminal trespass and obstruction from April 10th, 2020. His second case is one in which he's charged with simple battery and criminal trespass, 22 CR 2566G, and this is from an April 14th, 2020 incident. So about 4 days later.
Your Honor, if I may, I just need to give him a brief, very brief update and a breakout.
Understood. Let me just advise him on his rights, and then I'm going to put you, allow you to do a breakout. Mr. Dwyer, your attorney is going to be addressing your case with you. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Ms. Adams. Okay, Ms. Adams, if you want to go on your laptop, and then we will put you in a breakout. Ms. Champion, if you could put PD Samantha Adams and medical in a breakout, please. The deputy at medical, you will see a message on the screen to join a breakout room, please. Deputy at medical. All right. Jail court iPhone deputy, who do you have, please?
I have position number 13.
Oops. His attorney, in that particular matter, his attorney had waived his appearance. His bond modification is denied, and the case is further noticed for trial.
Thank you, ma'am. Have a good night.
Thank you. You too. Deputy, was that the only one?
Yes, for this floor, I have to go up to the 7th floor.
Who are we waiting on?
You will be waiting for position number 38 and position number 43 and 44.
Okay. All right. Thank you so much.
Yep.
Okay. We need to make an announcement on 4344. We're going to refer that to the competency calendar.
All right. Jail court iPhone. Are you still there? Deputy at jail court iPhone. Oops. Deputy Joseph Eunice, position 43 and 44 are going to be reset to November 16th at 11 p.m. So it's just position 38.
Copy that.
Thank you.
All right.
All right.
11 a.m.
11 a.m. Yes. All right, Miss Adams and medical, are we ready to proceed on Mr. Dwyer?
Yes, Your Honor.
All right. And is it going to be a negotiated plea?
Yes, on both cases.
All right, Mr. Dwyer, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, thank you. You may place your hand down. Ms. Falk, what's the offer for Mr. Dwyer in both cases?
Yes, Your Honor. On position 3, it is 12 months probation, balance suspended, stay away from 174 North Main Street, Alpharetta, which is the sit-go. No further contact with William Wilkerson on count 2, 12 months probation concurrent with count 1. We are waiving the issue of restitution given the age of the case and the fact that we have not received restitution from the victim. On count 2, on case number, position number 4, the state's recommendation on count 1 is 12 months probation, serve 1 day in jail. That was from May 14th of 2020. Balance suspended, no further contact with Yacht Vila, that is YACT. Stay away from the sit-go at 174 Main Street in Alpharetta. Count 2 would be 12 months probation.
Oh, I'm sorry, Ms. Falk, your Wi-Fi just lapsed for a moment.
My apologies.
Could you repeat the plea offer for position 4? After to stay away from the sit-go at 174 Main Street. Oh, yeah.
Who was a simple battery.
Oh, your Wi-Fi is maybe if you just stop the video, maybe the audio will come through. Okay, could you repeat count 2? Repeat
count 2 involved 12 months probation concurrent with count.
No, that didn't work.
Your Honor,
Okay.
You
Then I
probably have to leave the Zoom and then come back in.
I can state the recommendation that the state provided to defense on the record if.
Go ahead.
First, so it's 12 months probation to serve, I'm sorry, yeah, it was originally 12 months probation to serve 1 day, a balance suspended. I believe it's supposed to be a balance suspended, offer, Your Honor, that was what the state and I negotiated. No further contact with Yak Villa, that's YACT, last name Villa, VILLA. Stay away from the Citgo at 174 North Main Street in Alpharetta. And there was also a restitution. I can't remember whether or not the state was willing to waive that as well. But we can have Ms. Falk confirm that once she gets back on.
Okay. Ms. Champion, did Ms. Falk leave the Zoom and is coming back in?
I don't see her coming back in at this time, Your Honor.
Right. Let's just put a pin on this until the prosecutor appears.
Your Honor, can you hear me okay now?
Yes, lovely. Thank you.
Wonderful. Okay.
Okay, so we were on Mr. Dwyer on position number 4.
Yes.
If you could just, I know count 1 is balance suspended, stay away and no contact. Count 2, simple battery, is that probation?
Yes, 12 months probation concurrent with count 1. We are not requesting restitution due to the age of the case, and we have not received restitution from the victim, which is now the case is into its 3rd year. And we would state for the record the simple battery was spitting, just to clarify the basis of the simple battery. It did not involve, it involved harmful touching, but it was spitting.
So would it be non-reporting probation then?
Yes, because the balance is suspended as to both. It's actually, the defendant would just, it would just be balance suspended.
Oh, so there's no probation then?
No probation.
Okay, so let me amend that 12 months. So count 2 is simple battery, 12 months and serve 1 day, balance suspended. And for same thing for count 3. Okay. Does that clarify it for you, Ms. Adams?
Yes, Your Honor.
All right, and do you stipulate to the factual basis, venue and ID for both cases?
Yes, Your Honor, we do.
All right, Mr. Dwyer, if you can unmute medical. Sir, have you consumed any medication or alcohol?
No.
And are you satisfied with your attorney services?
Yes.
Have you understood the proceedings so far as well as your attorney's explanations? Have you understood the proceedings?
Yes.
And have you understood your attorney?
Yes.
All right, so if you decide to plead guilty to these charges in the 2 cases before you, these cases will then be closed and you will not have an opportunity for a trial to challenge these charges in a court of law. You will not get an attorney to go back to court to challenge the evidence, confront your accuser, present any defenses, and have the state try to prove the charges in both cases to a standard of beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of criminal trespass and obstruction of a law enforcement officer from May 10th, 2020?
Yes.
How do you plead, sir?
Guilty.
accept your guilty plea to these two charges. Your sentence is 12 months to be served on probation, but it will be suspended. You are not to return to the Citgo gas station at 174 North Main Street in Alpharetta, Georgia, and have no contact with William Wilkerson. Count 2 will be concurrent.
That's it.
For position number 4, how do you plead to 1 count of simple battery and 1 count of criminal trespass from April 14th, 2020? Mr. Dwyer, how do you plead to the second case for simple battery and criminal trespass?
Guilty.
Your sentence for both charges will be concurrent, is 12 months of probation to serve 1 day, balance suspended, no further contact with Yacht Villa, and to stay away again from the Citgo at 174 Main Street in Alpharetta, Georgia. That concludes your sentences. Thank you.
Thank you, Your Honor.
Jail court, we have position 38. Is Mr. McLean available?
That'll actually be my case, Your Honor, Attorney Pulliam.
Oh, that's right. I'm sorry about that. All right. This is State versus Leonard Watson, who is at the jail court iPhone, case 23 CR 5973F. Mr. Watson was accused of battery from a October 5th, 2023 incident. Mr. Watson, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Donnie Pulliam, who's on the Zoom as well. Do you see your attorney on the screen?
Yes, ma'am.
All right. This is going to be a non-negotiated plea. Is it still non-negotiated, Mr. Pulliam?
It's actually not going to be a plea today, Your Honor. We're just addressing bond considerations today, Your Honor. We're in a not guilty plea, and that's still standing.
All right, just give me a moment. For Mr. Watson, he had filed a waiver of arraignment and a not guilty plea on October 19th, 2023. He is presently on a $1,000 bond issued on October 6th, 2023. Yes, Mr. Pulliam?
Yes, today, Your Honor. We're about this bond modification to request that Mr. Watson be granted a signature bond. If you're not in favor of a signature bond, then a bond reduction to his $1,000 surety bond. Mr. Watson is 48 years old, Your Honor. He has 1 child, as well as 2 grandchildren who he does help to support. He is originally from Atlanta area and has been here the majority of his life, Your Honor. He has had employment working with Marriott as a housekeeper. He has told me that he thinks that he'll be able to get his job back, but if not, those skills are easily transferable to another organization, Your Honor. So we're just asking today that his bond be reduced today, Your Honor. He has been in custody now 33 days. This appears to be the only thing that's keeping Mr. Watson in custody. There does not appear to be any holds, neither there appear to be any additional charges.
All right, sir. Thank you. Ms. Falk?
Yes, Your Honor. I would just like to point out this defendant's history, which is a lengthy one. He has 41 cycles of arrest. His most recent arrest previous to this one was I believe a criminal trespass on September 11th of 2023. And then he was arrested for this case in October. So he didn't even make it a month. He also had a probation violation from 2021. That was from a 19 SC 169262 case, where it was felony obstruction of an officer and terroristic threats. He had a 2020 criminal damage to property, a burglary smash and grab arrest in 2020, as well as a another probation violation in 2019, a conviction for that felony obstruction, where he received 6 months in jail and 4 years and 6 months on probation. That was sentence was 11/20/2019, and he is still on probation, I believe, for that case. unless it was recently adjudicated. He also had a 2018 conviction for disorderly conduct and willful obstruction. So that just gives you an idea of this defendant's history that led to that $1,000 surety bond. In this case, law enforcement were directing a patrol at John Wesley Dobbs and Georgia State University's campus. They were stopped by employees of the racetrack at 120 Piedmont Avenue in Atlanta. The several bystanders pointed out the defendant who had been involved in a physical altercation. They approached the defendant, questioned him. He stated that the employees had accused him of stealing. Officers then met with employee Jadavian Hutchings. Mr. Hutchings stated that he believed that the defendant was stealing, asked the defendant if he was shoplifting, and then he asked him to leave the store multiple times. The defendant refused, became agitated, grabbed a broomstick, and struck Mr. Hutchings on the shoulder. At that point, Mr. Hutchings then tackled the defendant in order to protect himself and swatted him back with a dustpan as well. Mr. Hutchings, the employee, had multiple bruises and cuts to his hand where the defendant had struck him, and footage showed the defendant refusing to leave and striking Mr. Hutchings in response. We have spoken to the victim in this case, Mr. Hutchings. He stated that he confirmed the events in the warrant and stated his arm was swollen from being hit by the defendant. He stated it was his first encounter with the defendant. He wants no contact and wants the defendant to stay away from the location. So that was the basis, as I stated, for our recommendation in SCA for $1,000 surety bond, and that grant of $1,000 surety bond. We ask that it remain the same with the same conditions, given Mr. Watson's lengthy history and most recent arrests.
All right. Anything else, Mr. Pulliam?
Your Honor, just a couple of things. And so, again, we maintain our innocence, and that's why, we'll be taking this to trial. But additionally, just in regards to the original allegations against Mr. Watson, the reports also mentioned that no items were found on Mr. Watson. So the shoplifting charges were found to be baseless, Your Honor. And we, again, do tend to fight this at a trial.
He's not charged with shoplifting.
That's correct. No.
No.
But
Okay.
just the battery.
Understood.
They were mentioned by the state. So
at first blush, I'm not sure if a signature bond is going to serve anyone in this purpose. Mr. Watson has a consistent history of being booked into the Fulton County Jail almost every year, with the exception of 2022. He also has a consistent history of serving time and getting a time served disposition in many cases in his history. Unfortunately, he doesn't qualify for a bond reduction. As Ms. Falk has said, if this matter is being documented by video footage, this is clearly a case that needs to go to trial. Thank you.
Thank you, Your Honor.
Bond modification is denied.
Oh, yes, Your Honor, the state would also ask we would just like to revoke our recommendation on a plea on this case.
All right. All right, Mr. Pulliam and Mr. Watson, this case is further notice for trial. Thank you very much.
Excused.
Yes, Mr. Pulliam, thank you for being so patient. Thank you. All right. Jail Court iPhone Deputy, we have concluded with the proceedings. And thank you so much for traveling with your phone everywhere. Okay.
You're welcome. Thank you.
All right, thank you. Ms. Adams, I think we have gone over the cases for you with regards to positions 3 and 4. That one is a plea, and position 11 and 12. The deputy at Jail Court iPhone did have your client appear, and I reported to him that his case has been reset.
Thank you, Your Honor.
All right, thank you. All right, anything else with regard to your cases, Ms. Adams?
I think we might be done with my case.
All right, Mr. McLean, let's just go over, I can't remember where, I think, just starting back again, position 23, Brandon Logan was a plea. Position 24 was null pros. Position 25 was a plea. Position 26, Riley was arraigned and further notice. 27, Charles Rucker.
Thursday, November 9.
Okay. The 9 o'clock calendar?
Yes.
Okay,
Thank you.
and that would be.
Excuse me,
also
Judge, I had that going to
position
the
29. I'm sorry?
Excuse me, I said I had that going to the competency for 11-9. Is that going to
Mr.
regular or SAP?
We're not sure about going all the way to competency at this point. It might be better to keep it at 9.
27, 28, and 29 are being reset to November 9 at 9 a.m. pending council's request to put it on the competency calendar. Then it'll be further reset to the competency calendar on another date.
That includes 30, 31, 32, and 3.
Yeah, I'm sorry, correct. It goes all the way down to positions 31 and
Okay, I have it.
32
So it's going on
and
the
33. Yeah, all of them go to November 9th at SAP. You sure, Mr. McLean, that one's going on a 9 a.m. calendar?
Let's try that, Your Honor. We're hopeful.
Quite a few cases. So if you're going to put in the SAP calendar, otherwise all these cases go to the 11 a.m. calendar in the future. They won't be reverted to 11 a.m. on November 9th.
I'll talk with Mr. We may be prepared either way, Your Honor. I'll talk with Mr. Howard about that.
Okay. Please let Miss Grace know today.
Thank you.
All right. Thank you. All right, Miss Grace, I don't know what to tell you. Right now it's 9 a.m. until Mr. McLean
Consults.
calls you or emails you before 5 o'clock today. Okay. Let's do it before 3 o'clock today. All right, Mr. McLean?
Okay.
All right. Thank you. Position 34 and 35 were arraigned and reset
That's competency calendar, Your Honor.
Yeah, November 16th at 11 a.m.
Right.
Okay. Position 36 is reset to November 16. I'm going to put a note to a file that we had a non-negotiated plea hearing. The state's recommendation was accepted, and the matter is reset for victim to appear to testify as to restitution and all medical records. Ms. Falk? That's what I'm putting on the note to file.
Thank you, Your Honor.
Okay.
Right. Also, let me note, Your Honor, my experience with restitution hearings is that if the state gets hold of me and provides documents, we may discuss that amongst ourselves.
Oh, definitely. Yeah. Okay. Position 37, bond is reset to November 21st. 38, Watson is arraigned and further notice for jury trial. Position 39, West was a plea. 40 and was a plea. 41 is null cross. 42, Wilburn is arraigned and further notice. I can't remember the date. Was it further notice for trial?
That was Miss Woodbury's case.
Miss Grace, do you put
Yes, that's what I have for the notice for
further
trial.
notice for trial?
I believe y'all noted the Richardson date.
Yeah, that was Miss Wilburn. Yeah, that's correct. 43 and 44 is reset to November 16th at 11 a.m.
That's a competency
That
reason.
concludes the calendar.
Thank
Oh, did you all want me to go over probation? Or are we good?
I think we're good on that.
Okay. All right. Okay, everyone. Thank you very much. I will resume at 2 o'clock for the SEA calendar. But everybody else, Mr. McLean, Ms. Adams, please submit all your paperwork to Miss Grace as soon as possible.
Yes, thank you, Your Honor.
All right, everyone.
And Miss Grace, did you receive all the null pros for FTAs based on pleas?
Yes, I did, Ms. Falk.
Okay, thank you.
And the
All right.
transfer order as well.
Thank you.
All right. Thank you, Ms. Champion, Ms. Grace. I'll see you all at 2. Thank you.
Thank you.